May I permit to mention one extremely urgent matter, my lord. But the petitioner are required to undergo 6 months breach course, my lord. But as per the direction of the Honorable Supreme Court, my lord. But the notification which has been issued by the national, the NIOS, my lord, but the medium of instruction is has been restricted to only, my lord, the English and Hindi, my lord. But causing serious disadvantage to the petitioner, my lord, since the petitioners are well conversant with the Bengali language, my lord, and the petitioner, my lord, teaches in Bengali medium schools, my lord. And the last date of application is, my lord, 25th of December of this month, my lord.
File.
My lord, kindly takes up the matter.
But if the rules are framed that in
No, my lord, only the guideline, my lord. Only the guideline, my lord. No rules has been framed, my lord.
you file it in the department.
My lord, prayer for short service, my lord, and
No short service, you file it. 25th December is far away. File it in the department.
Well, may I permit? Well, may I permit it?
What the number to my lord,
Well, may I permit it to mention, my lord, two matters. My lord, today is the last online application date, my lord. Due to technical glitch, my lord, the petitioner could not fill up their form, online application form. Well, today is the last date. My lord, kindly take up this matter. My lord,
What glitch?
Is-
What technical glitch?
my lord, the petitioner when fill up their on date roll number and date of birth, it shows that mismatch of roll number and date of birth. There is, my lord, some technical glitch in the online portal itself of the respondent board, my lord.
Okay.
The petitioner,
For the board?
my lord, I have given
Usually,
notice.
Mr.
Ratul Vishwas appear, my lord.
Whether it can be checked in the course of the day so that you can file it.
My lord, I have filed, my lord will remember, I pray before your lordship to leave, my lord.
If you are eligible and only due to technical glitch your acceptance of the form is not being made, in that event the board can be asked to take instruction why it is not being
Then, my
accepted.
lord, kindly, my lord, fixed at 2 p.m., my lord, I bring the, my lord, respondent board, my lord.
3:30 তে রাখো।
3:30, yes.
হ্যাঁ 3 তে আছে 3:30 তে নেই 2 pm এ আছে 3 তে আছে 3:30 তে রাখো দেখি কি ব্যাপারটা এগুলো it will be restricted only to your technical glitch.
Yes, your lordship.
Huh?
My lord,
Otherwise, I
pursuant
have
of
to
the
hear the-
court order, they got the eligibility
There is
criteria.
date of birth problem and
Yes, your lordship.
Actually, my lord, what happened, my lord, they not my lord, updated after court order. They got the court order. They declare as a state pass in pursuance of it. They're not updated. In
then
that.
direction will be for updating and thereafter acceptance of the form.
Yes, my lord.
Let the board
My lord,
come.
may I permit to mention, my lord? My lord, yesterday, my lord, some of my friends' matter was mentioned and kept on Friday, my lord. That is, my lord, regarding 2016 selection process, my lord, where, my lord, less meritorious candidate got appointment, whereas, my lord, the more meritorious candidate not got appointment. And in this score, my lord, already in our reputation, my lord, RTI application and as well as the RTI reply is annexed. From that RTI answer, my lord, it is evident that less meritorious candidate got appointment, whereas the more meritorious candidate, my lord, not got appointment, my lord. My lord, and division bench judgment, my lord, specifically is that, my lord, that type of reputation, my lord, hereby the single bench, my lord, it will be kind enough, my lord, kindly take up that
Friday.
matter, my lord.
My lord, the other matters are coming up on Friday.
Yes, my lord.
Same.
Yes,
similar.
yes, similar matter. And in pursuance of division bench order, because the division bench not covered that less meritorious or more meritorious candidate, because that is specific observation.
Other matters are listed on Friday.
Yes, my lord. Yesterday.
Friday the rakho.
And these two.
On Friday, when I take up these matters, you
Okay,
indicate the numbers
Yes.
so that all can be taken
Yes,
up
yes.
together.
On Thursday, my lord, my juniors, they will appeal this court, my lord.
Yes.
May
I have
permitted,
few
my lord?
matters regarding this subject, my lord, that Mr. Shamim just said. My lord, I shall. Well, I'm
Because
thinking
of that matter, my lord, is not covered, and it is, my lord, mentioned in the judgment itself, my lord.
judgment of Priyanka Daskar, the
Mentioned,
division
my
bench
lord,
has mentioned.
at the time of hearing, my lord, I will appeal this court.
Well, I'm seeking leave of your lordship to move a matter urgently, my lord. These petitioners are, my lord, aspirants of TET 2022, my lord. My lord, TET 2002, my lord, regarding certain questions, my lord, several writ petitions have been filed before this Honorable High Court. This Honorable High Court, my lord, formed a committee, my lord. That committee, my lord, unable to file the report within time with regard to the disputed question. So the committee was modified by this High Court again. Thereafter, my lord, the committee, after lapse of 15 months, my lord, they submitted a report which is erroneous, my lord, from the face of the record. And the single bench granted us leave to challenge the report, my lord. My lord, by this writ petition, we are challenging the report, my lord. We are just 1 or 2 marks short, and its selection process is going on. We are losing our edge, my lord. If your lordship kindly takes it up this matter urgently, my lord.
Not urgently. File it in the report.
My lord, can it be taken up on Friday, my lord? I heard that similar matter has been your lordship present. Please to fix on Friday.
Not on Friday. You file and get the number.
Well,
We'll see what is the.
My lord, I have filed already one matter, my lord, that,
Hmm.
whether it can be listed or not.
Not on Friday, then next Friday you have to take.
Next Friday,
Not this Friday.
as your
The
lord.
other.
ঠিক আছে?
My lord, may I be permitted, my lord, to mention one matter, my lord?
Obliged.
My lord, I haven't found in the list, my lord's original site determination.
Ah.
My lord, there is one correction in one of the orders that my lord had passed, my lord. If my lord may kindly see, my lord, is only my lord 2 dates that
On
have been
Thursday you
wrongly.
mentioned at the time.
Thursday,
Yes.
my lord.
Thursday,
Thursday,
on Thursday, I'm taking up original side matters from 3 or 3:30. You just follow the list on Thursdays.
my
I
lord.
mentioned
I shall
Thursdays,
mention on
so
Thursday,
the AC will be there, court officer will be there, then
my lord.
Lordship,
Ma-
may I be permitted to mention one matter? This is for inclusion in the list, your lordship. This is pertaining to a POXO matter, your lordship might remember. It's pertaining to a civic volunteer of Agra police station, your lordship was hearing. The matter was,
Mr. Banerjee and Mr. Dotto is there.
yes, your lordship. That matter was, determination was changed and the matter was taken up on 14/11 by your
When I
lordship,
will
Justice
take it up.
Ghosh.
Assigned
The matter has been assigned, your lordship.
কবে নেব বলো তো? এখন just election এর যা চলছে। কবে নেব বলো? আচ্ছা, ওটাকে ডেট দিয়ে দাও, জানুয়ারি থেকে ডেট দিতে। জানুয়ারি ফার্স্ট উইকে আমাদের কিছু আছে কি? কবে দিয়েছে? 8-এ? 5th বা 6th দেখো, মন্ডে। 6th। 6th মানে মঙ্গলবার, মানে এটা পেনশন ম্যাটার্স। মঙ্গলবার দিন আমি সেকেন্ড হাফে 3টে থেকে। 6 January 3 PM.
I'm deeply obliged.
Well, it may be permitted to mention one contempt application. Order passed by a lordship for demolition of the illegal construction. Last 10 months, they have not in a position to. The contempt application, let me appear.
Where is the order?
Yes. Last but one paragraph, next page is the direction passed by a lordship where your lordship was pleased to hear that so the illegal construction is concerned and directed to dispose as early as possible, subject to correction. It is 10 months back, my lord, till that the authority is not in a position to see as early as
The
possible.
appeal?
Beg your pardon.
Whatever the appeal, it is not proceeding.
That portion has not been touched.
Only a part of that
Yes,
deviation has
yes,
to be
yes.
removed.
Cantilever.
Leaves the canopy.
Grateful to
Subject
you.
will also be, my lord. May I prefer my inclusion of this motion, my lord? Petitioner is a retired primary school teacher, my lord, not getting the revised pension, my lord.
So,
May I permit to mention one matter, my lord? For in inclusion, my matter is regarding my a petitioner is entitled to A gate scale, my lord. As per the division bench order, my lord, I have annexed, my lord, the division bench order, it is covered by my lord, division bench. Yes.
pension হবে?
Yes. I mean, no, not a pension, my lord, for A gate scale, my lord, he is working, my lord.
ये category,
Scale.
ये category মনে হয়, maybe ये category
Yes.
scale of-
I am paying restoration application. Restoration application.
Restoration of which repeated?
Restoration, I filed, my lord, before your Honorable Justice Rai Chakrabarty.
Group 2.
Group 2, my lord, primary. Thank you.
My lord, may I be permitted to mention, my lord, the matter is pertinent to the.
No, my lord. Oh, sorry, primary. MS.
Matters pertaining to the correction of the date of birth of the petitioner
Right,
in the
madam.
service
MSc.
book, my lord. My lord, the service period of the petitioner is expired in next month, my lord. The
না
matter
না
is
MSc,
decided, my lord, then
MSc
the
মানে কি
matter
আছে
will be
এটা?
entrusted to us, my lord. And it
What date of birth? Date of
আচ্ছা,
birth?
আচ্ছা, আমি দেখেছি মাধ্যমিক শিক্ষা
the
গেলে
correction of the date of birth of the petitioner, my lord. In his service book, my lord.
What will happen then? Correction of date of birth will extend his service.
My lord. By virtue of the interim order, my lord, the service period of the petitioner is extended to the next 1 year, my lord. The interim order has been expired on 30th January of 2026, my lord.
30th January it will expire. And he will retire on which date?
My lord, 31st January, my lord.
Are you sure?
My lord.
Yes, sir.
But one motion, my lord, I have challenged one transfer order, my lord, which was issued on 8 September 25, my lord, by the chairman of the council, my lord, who has no authority, my lord. There is a decision of the honorable coordinate bench also.
ये की monthly से আসছে না?
No, fresh filing, it is what was due to be listed on 8 March, 8 December.
আসেনি?
May I permitted to
I mean,
mention you?
I mean,
And one, my lord, A category, my lord, the one A category, my lord, the petition is claiming well A category scale of pay, my lord.
I'm praying for upgradation, my lord. Matter is running.
May I permitted to mention also, my lord, for non-prosecution, my lord. Primary matter, group 2.
No,
I'm mentioning
no upgradation. Recording.
Lordship, one thing, Lordship. Lordship is allowing the mentioning, if notice can be served, Lordship, kindly, because where board is the answering respondent, if no notice is served and it is listed, Lordship, it is very difficult to us also to take out the briefs and be prepared, Lordship.
যেগুলো নোটিশ থাকে মেনশনিং নেবেন।
Lordship, Lordship.
In the it is not given here. এখানে নোট দিয়ে দিন। No mentioning without notice. এটা ছিল তো আগে।
Grateful, Lordship.
আসো। নোট ছিল। এই একটা টাইপ চেয়েছিল কপি। না না এটা নয় এটা নয়। দেখুন বার করে দেখুন। আসুন। হ্যাঁ। By the present writ petition, this matter is appearing under the heading for orders. By the present writ petition, the petitioners seek for direction upon the respondents, particularly West Bengal Board of Primary Education, hereinafter referred to as WBBPE, to declare the petitioners who are candidates of 2-year diploma in elementary education within bracket in short DLED bracket close course for the session 2023-25 to be eligible to participate in the recruitment process in terms of notification dated 25th September 2025, read with notification dated 19th November 2025, and also to publish the results of DLED course. The petitioners
Obligation of
contained that they have all qualified in TET 2022 with B.Ed qualification. The petitioners have taken admission to 2-year course in DLED for the sessions 2023-2025. Stop. The petitioners have appeared in the final examination of DLED and the results are awaited. The petitioners intends to participate in the ongoing recruitment process which has been initiated by WBBPE in terms of its notification dated 25th September 2025, read with notification dated 19th November 2025. Para. Upon hearing the learned advocates for the respective parties, following issues have fallen for consideration. Number 1, whether the petitioners who have qualified in TET 2022 is eligible to participate in the recruitment process initiated with a notification can take the notification
28 June 2018. The NCT
28.
notification.
What is the recruitment notification?
25/9.
No. This is of 25th September 2025. What is the number of the notification?
Memo number.
That's the na? September 2025. We read with 19th November and numbers look already. Whether the petitioners, being the pursuing candidates, be allowed to participate in the recruitment process where the results are awaited. Whether the WBBPE has any deliberate latches to publish the results. Firstly, secondly, fourth, whether there is suppression of material facts by the petitioners in the writ petition. এবারে heading করে দেবেন issue number 1. Admittedly, the petitioners have passed TET 2022 with B.Ed qualification. Mr. Sabir Ahmed, learned advocate for the petitioners, submit that as per the recruitment notification for the post of assistant teachers, you typed a patient. তামিমকে ফোন করব post of assistant teacher in primary school, comma, the candidate should have TET qualification and diploma in elementary DLED course করো, and DLED stop. The petitioners are all TET qualified of the year 2022. Petitioners have already completed the DLED academic course of 2 years for the session 2023-2025. Although the board has conducted the examination of final semester in DLED for the session 23-25, but till date they have not published the results. Stop. In the meantime, the recruitment notification has been published on 25th September 2025. The petitioners intends to participate in the ongoing recruitment process. On the contrary, Mr. Subir Sannal, learned senior advocate appearing for WBBPE, submits that by notification dated 28 June 2018, the National Council of Teacher Education, within bracket in short NCTE, comma bracket close, included the candidates with graduation with at least 50% marks and Bachelor of Education within bracket BA as one of the qualification for appointment as teacher in classes 1 to 5. Provided that upon appointment he or she shall mandatorily undergo breach course recognized by NCTE within 2 years of such appointment as primary teacher. Challenging such notification of NCTE, several writ petitions were filed in different high courts throughout India. The Honorable Rajasthan High Court was the first court to set aside the said notification of NCTE. The aforesaid order of the Rajasthan High Court was assailed before the Honorable Supreme Court in SLPC within bracket C 20743 of 2021 bracket লিখুন দেবেশ শর্মা ভি লিখবে না দেবেশ শর্মা ভার্সেস ইউনিয়ন অফ ইন্ডিয়া In the meantime, the WBBPE issued a notification for conducting TATE 2022. দেখুন তো আরেকটা ফাইল আছে যাতে জাজমেন্টস গুলো দেওয়া আছে। Issued a notification being number 1572 slash WBBPE slash 2022. What is the date of this notification for conducting the TATE 2022?
22nd of September 2022.
Dated 22nd September 2022. একটু আন্ডারলাইন করে রাখুন,
22
চেক করুন।
না 22 নোটিফিকেশন হচ্ছে 29
29 September 2022.
নোটিফিকেশন
নোটিফিকেশন ডেটে জানতে
True.
মানে সেম ডেট তো যেদিন একটা রিক্রুটমেন্টের নোটিফিকেশন হয়।
Notifying that the board is going to hold TATE 2022 for qualified trained candidates, including B.Ed candidates of West Bengal, seeking appointment to the post of assistant teacher in government aided / sponsored / junior basic primary schools. The said notification was assailed by some of the DLED candidates before this honorable court in WPA number 23202 of 2022 within bracket Ujjwal Haldar and others versus Union of Indian others. The said writ petition was disposed of, directing that the candidature of B.Ed qualified candidate shall abide by the result of pending special leave petition, special is the capital word, na? Special leave petition before the Honorable Supreme Court in Devesh Sharma versus Union of India. Disposed of on না দেবেশ শর্মাতে না, এটা ডিসপোজড হয়েছে রায় সাহেবের অর্ডারে। এটা ডেটটা দেখে না। Including the fate of the present petitioners, whose eligibility was covered by the notification of NCT dated 28th June 2018. The board has also issued notification being number 1770/WBBPE/2022, notifying that the candidates having B.Ed qualification will be allowed to apply for and appear in TET 2022, subject to the final result of SLPC number 20743 of 2021, pending before the Honorable Supreme Court. By its judgment dated 11th August 2023, the Honorable Supreme Court was pleased to set aside, affirm the order of the Honorable Rajasthan High Court and set aside the notification being F number NCTE-REGL 012/16/2018, dated 28th June 2018. Thereby holding that the B.Ed is not a requisite qualification for teachers for primary school, and that the central government has acted against the constitution and the laws. The effect of the said judgment of the Honorable Supreme Court is retrospective, meaning thereby that the petitioners who qualified in TET 2022 with B.Ed qualification cannot be treated to be valid upon setting aside of notification dated 28th June 2018. Some of the candidates who were already appointed as teachers in primary school in the state of Madhya Pradesh filed a miscellaneous application before the Honorable Supreme Court seeking to give prospective effect to the judgment. Upon hearing, the Honorable Apex Court protected only those candidates who were already appointed and none else. To buttress his contention, he relies on decision of Honorable Supreme Court in Devesh Sharma versus Union of India reported in Suprana. It citation টা দিতে হবে এখানে. Reported in 2023, volume 18 SCC 339, as well as the clarification order passed subsequently reported in 2024 SCC online SC 3096. He also indicates that the added respondent and others preferred a writ petition before this honorable court for praying inter alia for cancellation of TET 2022 results, as well as certificates issued in favor of the candidates who appeared in TET 2022 with their B.Ed qualification. In terms of notification dated 29 September 2022. Who is it? Can you place that order of Justice Mantha?
Yes, madam.
The interim order and the final order. Final order means the interim order being made absolute?
Start with 156 and 160.
For the 2022 selection. That is for
The Honorable Court was pleased to pass order, not this one, pass order not to process recruitment for the post of assistant teachers for 2022 candidates with B.Ed qualification or DLED within bracket NIOS qualification under WBBPE. Talk. The said order has been made absolute till the disposal of the said writ petition. Thus, the petitioners with state 2022 qualification, state 2022 qualified with B.Ed degree are not eligible to appear in the ongoing recruitment process. Deal. Hmm. Hmm. Mr. Piyush Chaturvedi, learned senior advocate appearing for added respondent numbers 10 to 15, adopting the submission of Mr. Sannal, learned senior advocate for WBPE, indicates that with the passing of the order in Devesh Sharma Supra, the notification dated 28 June 2018 has become non-existent or void ab initio, that is, from the very beginning. By the clarificatory order passed in Devesh Sharma Supra, only candidates who were already been appointed was protected and none else. Orders have been passed in earlier writ petition where the fate of the candidates who qualified in TET 22 was subjected to the decision rendered in Devesh Sharma Supra. No appeal has been preferred against the said order. Notice has also been issued by the board notifying the fate of the candidates of TET 2022 to be subjected to the result in Devesh Sharma Supra. Thus, the petitioners who claims to be state qualified is upon decision Devesh Sharma is not eligible to appear or participate in the ongoing recruitment process. In reply to such contentions raised on behalf of the board, respondent board, as well as added response number 10 to 15, Mr. Sabir Ahmed, Mr. Ahmed, learned advocate for the petitioner, referring to paragraph number 80 of the decision in Devesh Sharma Supra, submits that the B.Ed qualification which was introduced as per statutory notification of NCTE is valid till it is declared illegal or unconstitutional by the court. Even if the board is of the opinion that such notification was unconstitutional or for any reason illegal, the same had to be stayed or set aside by a competent court before it could be ignored. Therefore, the candidates who qualified in TET 2022 are valid candidates till the decision was rendered in Devesh Sharma Supra, declaring such notification of NCTS as unconstitutional. Furthermore, referring to paragraph 81 of Devesh Sharma Supra and relying on the decision of Honorable Supreme Court in State of Manipur versus Surya Kumar Okram, reported in 2022, Volume 9 SC Seat 723, he submits that a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law. In declaration of the law, the doctrine of prospective overruling is applicable. Therefore, thus, such a declaration rendered in Devesh Sharma Supra can never have retrospective effect, for which reason the Honorable Supreme Court has protected the candidates who were already appointed as primary teachers. In the same breath, the petitioner's qualification of TET 22 needs to be protected. He further indicates that TET and recruitment process are distinct and different. Needless to mention that the certificate of TET 22 has not yet been recalled or cancelled by the board. Therefore, the board in no way can challenge the validity of the candidates who succeeded in TET 2022. Para. There cannot be, it is not in dispute that the petitioners before this court have passed TET 2022 and all have been issued certificates.
Yes.
And all have been issued certificate to that effect. The TATE 2022 was conducted allowing the candidates with B.Ed qualification on the basis of the notification of NCTE dated 28th June 2018. Para. For better appreciation, the said notification is reproduced here under. Notification. দেবেশ শর্মা
এটাই তো?
করা আছে।
কোনটা তাই? 104 মানে
হুম?
104 in the writ petition. আমাদের writ
Take it
টা
from দেবেশ শর্মা। এই দেবেশ শর্মার এই কোডটা নিয়ে নিন, পেজ 26।
একশো 107
এটা কোড করবেন এখানে। Thus, by dint of the aforesaid notification, B.Ed qualification, Bachelor of Education with a B.Ed qualification was included for appointment of assistant teachers in the primary schools. The aforesaid notification was the aforesaid notification was set aside by the Honorable Rajasthan High Court in Rajendra Singh Chotia versus NCTE reported in its 2021 SCC online Rajasthan Raj 4372. The said order of the Honorable Rajasthan High Court was assailed in appeal before the Honorable Supreme Court in SLP number to the along with other writ petitions. 20743 of 2021. The Honorable Apex Court in paragraph number 63 held as follows. 63 set out. Thus, by the judgment in Debesh Sharma Supra, the notification of NCTE allowing B.Ed qualification as a requisite qualification for appointment of assistant teachers of primary school was set aside. Para. Needless to mention that the TET 2022 qualification, TET 2022, needless to mention that the notification of the board WBPP for holding TET 2022 was assailed before this honorable court in WPA number 23202 of 2022, Ujjwal Haldar and others versus Union of India and others. The said writ petition was disposed of on 18th November. Give that order.
18th October.
18th October. October 2022 as follows. Are you considering? Okay. This has been annexed to the writ petition or can application? Can application. Which is the page number? I did.
143.
Are you considering? Pursuant thereto, sorry, একটা লাইন ওখানে অ্যাড করব। Thus, the fate of TET 2022 candidates were subject to the special leave petition in Debesh Sharma Supra. Result of the special leave petition in Debesh Sharma Supra. On 7th November 2022, the board issued a notification notifying that all the steps taken and to be taken in terms of notification number 1572 slash WBBPE slash 2022 dated 29th September 2022 by which the TET 2022 was to be conducted shall abide by the result of SLPC 20743 of 2022 ব্র্যাকেটে করুন the year has been wrongly typed. Therefore, there cannot be any quarrel that the fate of TET 2022 was subjected to result in Devesh Sharma, Supra. Mr. Ahmed has strenuously argued that Mr. Ahmed, learned advocate for the petitioner, has strenuously argued that the effect of the decision of Honorable Supreme Court in Devesh Sharma Supra is to act retrospectively, to act prospectively, prospectively, and not retrospectively. Clarificatory order. In order to examine the argument as advanced on behalf of the petitioner as aforesaid, it would be apposite to reproduce the clarificatory order passed in miscellaneous application in Devesh Sharma Supra. In given fact, এখান থেকে নিয়ে এসে এই অবধি। In view of the aforesaid, it is found that the Honorable Supreme Court has categorically held that ordinarily a judgment acts retrospectively unless it is specifically stated to be otherwise. It has further been clarified that the benefit has been extended only for the candidates who were appointed prior to date of the judgment, that is 11th August 2023. It has also been held that mere selection of such candidates or their participation in the process will not entitle them for a benefit under the present order. Mr. Ahmed has relied on Surya Kumar Okram Supra to impress upon the court that the order in Devesh Sharma has a prospective effect. Following proposition were laid down by Honorable Supreme Court in Golaknath. Paragraph 33. Hmm. '33 and 34. হ্যাঁ গোলকনাথ আছে 14 আমি বলে দিচ্ছি দাঁড়ান 14 বলে দিলেন কোথায় খুঁজবেন গোলকনাথ হচ্ছে 1967 SCC online SC 14. The proposition as laid down in Goloknath has been followed by the Honorable Apex Court in Suraj Kumar Okram, and it clearly lays down that the doctrine of prospective overruling can be applied by the Honorable Supreme Court and the relief can be molded by the Honorable Court in exercise of its power under Article 142 of the Constitution. For such reason, the argument advanced on behalf of the petitioner is not sustainable. In view of the above discussion, since the notification as set aside in Devesh Sharma Supra has become non-existent, therefore, the eligibility of the TATE 2022 qualified candidates to participate in the ongoing recruitment process is questionable, rather to hold that they are not eligible to participate on the basis of TATE 2022 qualification. It will not be out of place to reproduce the orders passed in a writ petition being WPA 2661 of 2024, wherein the petitioners have sought for cancellation of the results of TATE 2022 and the certificate issued thereupon. কোট করবেন
$156.
156 না 155 এর আগে অর্ডার নেবেন 12 নম্বর এবং 156 এর 159 এর প্যারা 16 এখন একটা কোয়েশ্চেন তো নিয়ে চলে গেল কোয়েশ্চেনটা কি নেক্সট ইস্যু নাম্বার 2 করে দিন কোয়েশ্চেন whether the pursuing candidates are whose results are awaited can appear. Mr. Ahmed, learned advocate for the petitioner, submits that the petitioners have completed their DLED course and the final exams have also been conducted by the board. However, the results have not been declared. Relying on Soumen Pal and others versus Stravoni Naik and others, he submits that since Rule 6.2 of the West Bengal Board of West Bengal Primary School Teachers Recruitment Rules 2016 does not provide any cutoff date to obtain the qualification. The qualification on the last date appointed for receipt of application is to be considered. If the board publishes the results it will definitely allow the petitioners to participate in the ongoing recruitment process. Referring to para করুন Mr. Channa Lanet, senior advocate appearing for BPE, submits that as per the আচ্ছা ওই উপরে একটা রুল বললাম না ওয়েস্ট বেঙ্গল টিচার্স রিক্রুটমেন্ট রুলস ব্র্যাকেট করুন হিয়ারিন আফটার রেফার টু অ্যাজ দি রিক্রুটমেন্ট রুলস 2016 referring to rule 6.2 of the recruitment rules 2016 as well as amended as well as recruitment notification dated 25th September 2025, he submits that the provisions and the advertisement is unambiguous that the candidate must have passed 2 years DLED on the date of advertisement. Since the petitioners do not possess the said qualification on the date of advertisement for recruitment, they are ineligible to be taken into zone of consideration. The results, he informs the court that the final exam has been conducted only on 15th November 2025. The board requires a reasonable time to publish the results. In similar circumstances, this court in earlier writ petitions have turned down such prayer in support of his contention. He relies on the decision of this court passed in Koeli Chakraborty and ORS others versus State of West Bengal and others, and one other writ petition reported in 2017 SCC Online Calcutta 356. Further relying on the decision of Honorable Supreme Court passed in Tej Prakash Pathak versus Rajasthan High Court, reported in 2025 2 SCC 1, he submits that the rules of the game must not be changed midway. ঠিক আছে? Or after the game has been played. Stop. Once the recruitment process commences, the rules cannot be changed thereafter. As on the date of advertisement, the petitioners did not possess the required qualification. The requirement cannot be changed or molded by allowing the petitioners to participate in the recruitment process who are till date pursuing the course since the final results are awaited. আচ্ছা ওপরে না ওই মিস্টার আহমেদের সাবমিশনে একটা জায়গা শেষে আবার নিন একটা পয়েন্ট he also indicates that referring to the supplementary affidavit, he indicates that some of the candidates with who have qualified TET 2022 has been allowed by the board to participate in the recruitment process. এটা এই পোর্শনটা না ব্র্যাকেট দিয়ে ওপরে দিয়ে দেবেন ওপরে যেখানে টেট 2022 এর এটা করেছিল ইস্যু নাম্বার 1 এই পোর্শনটা ওখানে চলে যাবে
only one indulgence, uh, qualified TET 2022 with B.Ed degree. This need to be
with BEd degree. এই সাপ্লিমেন্টারিটা পাচ্ছি না গো। হ্যাঁ দেবনাথ বাবু
সাপ্লিমেন্টারি করছি, এই সাপ্লিমেন্টারিটা।
You have got a copy of the
Yes, ma'am.
supplementary? Please. ওটার আনসার হ্যাঁ ওটা বলছো তো have been allowed, to which Mr. Sarnal has informs the court, informs the court that though such application has been accepted, but it is the view of the board not to allow any candidate of TET 2022 qualified with BEd. কোথায় ছিলাম ওখানে চলে আসুন।
My lord, we have referred another documents, my lord, a report filed by them in the coordinate bench, my lord, where the secretary of the board informed the court that
Yes.
yes,
ওই রিপোর্টটা কোথায় রাখবেন? ওইখানে উপরেই। He has also placed reliance on the report filed by the board in WPA 5122 of 2024 within brackets Subhrangsu Pathak and others versus the state of West Bengal and others, wherein he submits that the board has considered that the candidates passed in TET 2022 with BEd training qualification may be considered as TET 2022 passed candidates, since the candidates were already declared as TET 2022 passed candidates. Mr. Sannal, in reply, has clarified that the board has stated before the court in such report that although TET 2022 has been shown to be qualified, but that is subject to the solemn order of the Honorable Supreme Court in Devesh Sharma Supra. এবারে চলে আসুন, এটা কি ছিল কোয়েশ্চেনটা? হ্যাবিটিং না? এটা ওনারটা না? এটা ওনার প্রশ্ন।
Damar.
Mr. Piyush Chaturvedi, learned senior advocate appearing for the added respond numbers 10 to 15. submits that the petitioners have not yet passed DLED. As per the notification, the petitioners, the candidates who have passed DLED on the date of advertisement can apply. Relying on the decision of Honorable Supreme Court reported in 2025, Honorable Supreme Court in Porimal Kumar and others versus State of Jharkhand and others, he submits that 25-1 SCR 1953, he submits that the rule of the game cannot be molded once the recruitment process is initiated. In order to assess the issue under reference, it would be profitable to reproduce Rule 6.2 as hereunder. Rule 6.2 টা কোথায় পাবেন? So many পাবেন। এটা লাগবে। প্যারাগ্রাফ 3 তে আছে। এই যে 2টা, হ্যাঁ? The aforesaid rule provides that the candidates shall possess the minimum educational and training qualification as prescribed by National Council for Teachers Education prevailing as on date of publication of recruitment. In Somen Pal Supra, the Honorable Court, Apex Court, has considered the provision and has observed that to ensure that the latest prescription of NCT should be made applicable for any recruitment, the rule also provides that qualification prescribed by the NCTE within inverted comma prevailing as on date of publication of recruitment notification must be possessed by the candidate. It further observed the intendment of Rule 6.2 of Recruitment Rules 2016 is only to declare that qualifications as prescribed by NCTE and that are prevailing on the date of publication of the recruitment notification should be possessed by the candidate. The Rule 6.2 as well as the notification issued by the board goes to show that the candidates should possess the requisite qualification on the date of publication of the advertisement. It is pertinent to note that in Somen Pal Supra, the notification of the board allowed the pursuing candidates of DLED to take part in the recruitment process, which is quite distinct from the present notification, which in unambiguous term in 3B of the advertisement clearly stipulates that the candidates who have passed would be allowed to take part in the recruitment process. Furthermore, this court finds substance in submissions of Mr. Chaturvedi and Mr. Sannal and Mr. Chaturvedi, senior advocates, that the rule of the game cannot be changed as held by the Honorable Supreme Court in Tej Pratap Supra. Therefore, a pursuing candidate cannot be, whose results are awaited, cannot be allowed to participate in the recruitment process, which has already been initiated with a notification dated 25th September 2025, read with notification dated 9th November 2025. আচ্ছা তেজ প্রতাপটা না একটু এই জাজমেন্ট থেকে কোট করবেন তো এই যে দেখুন তেজ প্রতাপের 53 54 দাগ দিয়ে দিন 54 তেজ প্রতাপের মানে না এটা হচ্ছে এই জাজমেন্ট ওই পরিমল কুমার যে জাজমেন্টটা আছে তার 53 আর 54টাকে কোট করবেন তেজ প্রতাপ নিয়ে এসছে The position of law as per Tej Prakash Pratap Supra is therefore clear that the recruitment process commences from the issuance of advertisement and that eligibility criteria as laid down therein cannot be changed midway during the recruitment process unless the extent of rules or the advertisement permits such a change after issuance. Even if such power to amend is reserved in the advertisement or the rules, it must be tested on the anvil of Article 14 and pass the test of non-arbitrariness. Next question. 3. Whether there was any intentional and deliberate laches on the part of the board to publish the results of DLED. The petitioners have been admitted have taken admission in course, DLED course, 2 years DLED, 2-year DLED course of 2023 and to 2025. It is not in dispute that after completion of the course, the petitioners have appeared in the final examination only on 15th November 2025. Therefore, reasonable time is required for assessment of the candidates. In view of the above, taking the date of final examination in mind, this court is of the view that there is no such laches on the part of the board in not publishing the results. However, this court deems fit that the results of DLED, 2-year DLED course, be published as expeditiously as possible. Next issue. Next issue. Whether there is any suppression of material facts. Mr. Tannal Lanet, senior advocate appearing for the board, submits that previously some of the petitioners arrayed in the present writ petition has filed an earlier writ petition wherein they have prayed for updation of the data and for considering the DLED degree holder valid candidates to appear in primary teacher recruitment process conducted by the authority. The said aspect has been suppressed in the present writ petition. The petitioners can only seek equity if material truths are disclosed before the court. When a party suppresses facts or makes false statements, the court cannot permit to use its process for such a purpose. Entertaining the matter, full stop there, entertaining the matters on merits in such circumstances would amount to encouraging dishonest conduct. A litigant who seeks relief must show respect for the truth. When he does not do so, একটা করে নি না ট্রুথ অবধি উনি করেছে ঠিক আছে when he does not do so he cannot expect the court to exercise discretion in his favor. To buttress his contention he relies on the decision of Honorable Bombay High Court in Ram Rao Tukaram Patil and others versus State of Maharashtra. Through Secretary Department of Cooperation and others, along with one other writ petition reported in 2025 SCC Online, Bombay, BOM 4462. In reply to such contention, Mr. Ahmed, learned advocate for the petitioner, submits that the cause of action of both the writ petition are distinct and different. Therefore, there is no deliberate suppression of material facts before this court. There cannot be any quarrel that some of the petitioners who have you made the serial numbers?
No. They have only given a number, but they have not given the serial number.
How many candidates are there?
They have alleged that 67.
113.
113.
Serial number গুলো দিয়েছিস?
না না লিখে এনেছিলাম
এটা মানলো কি? প্রথমত 62. Mr. Shanal said 62.
62.
113 লাস্টে বলেছি
About so, Ahmed, will you kindly check and then report to my court officer how many are there?
Because they are saying so, my lord, I don't have that writ petition. Let the
Then
board.
you check it with Mr. Ahmed and provide the number. Okay.
I'll
Some of the candidates করে dash দিয়ে দিন ওখানে numbers টা দিয়ে দিন. Have filed the writ petition, earlier writ petition being WPA 10942 of 2025, wherein a direction has been sought upon the respondent authorities to update and or alter teacher training data of petitioner in West Bengal Board of Primary Education database and certify in this regard, and also to take necessary steps so that the petitioners can be considered as DLED degree holder valid candidates to appear in the primary teachers recruitment process conducted by the authority. The aforesaid writ petition has not been disclosed in the present writ petition. This court is of the view that such aspect ought to have been disclosed in the present writ petition. In view of the above discussion, this writ petition falls short of merit. Dismissed. Sorry. Next again.
Obliged.
Thank you, Mr.
Lord, may I just indicate one thing? Since your lordship has already discussed the Tate part, but Lord, may I pray stay on those aspects, Lord. So for the Tate part is concerned.
No. Okay.
Obliged.
By the present writ petition, the petitioners seeks for publication of the final results of DLED course session 23-25 prior to the last date of application dated 25th September 2025. And directing the respondent, particularly respondent number 2, 3, and 4, to accept the application of the petitioners for selection process in connection with recruitment notification dated 25th September 2025. এখানে 22 টা ওখান থেকে নিয়ে নেবে, ঠিক আছে? এখানে একটা দিয়েছিল, লিস্ট দিয়েছিল। লিস্টটা বলো। দেখো তো এটা কোথায় ছিল, উনি যেটা এটা দিয়েছিল, কাগজগুলো দিয়েছিল না? এই লিস্টটা বলো, এই লিস্ট, এটা পিটিশনার্স এর লিস্ট আছে, ঠিক আছে? হ্যাঁ হ্যাঁ দি in the present writ petition, some of the petitioners have qualified in TET 2014, comma, some have qualified in TET 2022, and some with TET 2023. The details of which are reproduced, table করতে পারবেন এরকম? In a tabular form as here under. এই টেবিলটা করবেন, এইটার হবে, দেখে মিলিয়ে নি। Next, table পরে, the petitioners herein contain that all of them have completed the DLED course, which is required for the ongoing recruitment process. However, since the results have not been declared as yet, they are unable to participate in the recruitment process. Initiated with a notification dated 25th September 2025, read with notification dated 19th November 2025. Mr. Firdos Samim, learned advocate for the petitioners, submits that the petitioners have qualified in TET 14, TET 2022 and TET 2023. The TET qualification is valid for life. Therefore, placing reliance on the notification issued by NCT dated 9th June 2021, he submits that once a candidate qualifies TET, it is valid for life. Until and unless it is revoked and or cancelled by a competent authority. None of the certificates issued in favor of the petitioners have been till date cancelled by the authority, that is the West Bengal Board of Primary Education, WBBPE in short. একটু বলুন তো রাইট টু এডুকেশন অ্যাক্ট আছে কিনা ওনার কাছে আছে মিস্টার শামীম? Mr. Shamim,
Yes, madam.
you are carrying right to education act.
That's my junior doing. Section 23.
He further submits that the object of right to education act is to appoint
If my lord's desire were a soft form, it is
qualified section 23.
section 20. That is
Appoint qualified teachers so that the impart of education in all the states of India is enhanced, and the children studying in such primary schools are benefited by the service of the qualified teachers. He refers to section 23, which deals section 23 of the Rights
16.
of Children to Free and Compulsory Education Act 2009, hereinafter referred to as Act of 2009, relating to qualifications for appointment and terms and conditions of service of teachers. Section 23(1) is the provision where the academic authority has been empowered to prescribe qualifications for teachers in elementary schools. And subsection 2 of section 23 empowers the central government to relax the minimum qualifications prescribed by the academic authority under certain circumstances and for a limit. The notification of NCTE dated 23rd August 2010 lays down the necessary qualification for teachers both at primary as well as upper primary level. Next, para করো না? The petitioners who have qualified in TET 14 as untrained candidates have taken admission in diploma in elementary education, in short DLED, to make themselves qualified as required by subsequent notifications of the NCTE. The petitioners who have qualified 2022 and 2023 have also taken admission and completed the course of DLED, of which results are awaited. Due to arbitrary and high-handedness of the board in non-publishing the results, the rights of the petitioner to at least participate in the recruitment process has been affected. He indicates that the decision of Honorable Supreme Court in Devesh Sharma versus Union of India does not cancel the TET certificates or TET qualification. The notification of the NCTE dated 28 June 2021 allowed the graduates with at least 50% marks and Bachelor of Education BA degrees to apply for appointment to the post of assistant teacher of primary school. TET 2022. TET 2023, this is TET 2023, there is no BA.
No.
No. Until 22.
Only.
822 only BA teacher.
Because of that, after TET
11th August
2022,
2023, the qualification
become redundant because that notification goes. So in TET conduct guideline, as per the NCT, whatsoever the eligibility criteria, as per the eligibility criteria, they will set it the TET. That's why it is not mentioned in that point.
Assistant teachers. TET 2022, the candidates with TET 2022 during the subsistence of the notification dated 28 June 2021 as co-
2018.
Huh?
28 June 2018.
18 yes, 18 হবে, sorry, thank you.
He had introduced in the year 2008.
18 ঠিক 20th when the subsistence of notification dated 28th June 2018 has appeared and has been qualified. The petitioners who have appeared in date 2023 has appeared as pursuing candidates of DLED course as per the guidelines of the NCTE. Thus, once the petitioners have qualified the TET, the same cannot be revoked and cancelled or arbitrarily withdrawn. The certificates and the qualification of TET of the petitioners, TET 2014, 2022 and 2023 are valid till date. The board has not filed any petition before this court seeking for revocation. Sorry, petition to has not taken any steps for revocation and or cancellation. And therefore is debarred from challenging its own action. The petitioners herein seeks for publication of the final results of the DLED so that they get the opportunity to take part in the recruitment process. Para. As per the the 2.1 Mr. Sami, Mr. Samim, which is the notification which gives that the academic period is 2 years.
Academic, that is NCT. It is annexed with my. It is annexed with my reputation. NCT. No. There is NCT notification.
Regulation.
108. Page 108 of my norms and standard. No, that is 108. That is
as per the norms
and
standards of
for diploma.
for diploma in elementary teacher education program leading to diploma in elementary education within bracket DLED The duration of DLED program shall be a duration of 2 academic years. The release notice dated 30th June 2025 goes to show that the academic year has ended on 30th June 2025. The board ought to have published the results within the academic year. The duration as stipulated in the standard norms, stipulated in norms and standards would show that the board is statutorily bound to publish the results. Only the students have been permitted to complete the program within a maximum period of 3 years from date of admission to the program. Such latitude has not been provided to the board, which is duty bound to complete the course within the stipulated period. In light of his aforesaid submissions, he prays for specific direction upon the authority concerned to publish the results of DLED and also allow the petitioners to participate in the selection process, recruitment process. On the contrary, Mr. Subir Sanna Lanet, senior advocate, appearing for the West Bengal Board of Primary Education, WBB in short করে দিন, WBBPE, submits that the petitioner's writ petition has a jumbled up cause of action, which is distinct and different from each other. Therefore, on such score, the writ petition is not at all maintainable. Date 2022 এর আগের যেটা বলেছিলাম ওই সাবমিশনটা মিস্টার সান্নালে কোট করবে আগের রিট পিটিশন থেকে ডেট 2022 এই আইটেম নাম্বার 1 আচ্ছা ওখানে ডেট 2022 এর এলিজিবিলিটি নিয়ে বলেছে একটা সাবমিশন নিয়ে রাখুন ওখান থেকে অ্যাড করে নেবেন The petitioners who have appeared in date 2022 has appeared with B.Ed qualification, which has been struck down by the Honorable Supreme Court in Devesh Sharma Supra, and therefore is not qualified in TET. Further, none of the petitioners have passed DLED, and therefore they are pursuing candidates. As per the notification plus advertisement for recruitment, the candidates who have passed the course on the date of advertisement are eligible. Therefore, the petitioners are also lacking on such score. He further indicates that at the time of state examination, the certificates are not verified. And as per the instruction, it will be evident that the eligibility of the candidates appearing in the TET has not been verified by the board. The particulars of the candidates and subjects are mentioned as per declaration by the candidates in the application form. The appointing authority has the right to verify the same before appointment. Therefore, the certificates issued of TET qualification is subject to scrutiny and verification. He informs the court that the final examination of DLED has been completed only on 15th November 2025 and will be published within a reasonable time frame. He seeks for dismissal of the writ petition. Mr. Yes.
In this petition, there are some TET 2023 TET candidates. I have also challenged that TET qualifications because
He also submits that the candidates who appeared in TET 2023 appeared as pursuing candidates of DLED course. However, from the records, it will be evident that the admission notification to DLED course has been issued on 17th August 2023, which has been extended till 8th October 2023.
8th November.
8th October 2023 by submission of applications, 8th October. By a notification dated 8th November 2023, merit list was directed to be published by the institutions. The TET 2023 has been notified on 13th September 2023, which makes it clear that on the date of notification dated 13th September 2023, there was no occasion that the petitioners were pursuing DLED course. He seeks for dismissal of the writ petition. Mr. Piyush Chaturvedi, learned senior advocate appearing for respondent numbers. None is there. Seven and eight. Also submits that the with the passing of the judgment in Devesh Sharma Supra, the eligibility of graduate with at least 50% marks and B.Ed qualification has been done away with. Done away with. Retrospectively, from the date of such notification, that is 28th June 2018, and has become non-existent. Therefore, the candidates with 2022, date 2022, cannot claim their right on the basis of such qualification. As regards date 2023, he also indicates that at the time when the notification was published on 13 September 2023, the petitioners were not pursuing their DLED course. The ক্যানটা দিন তো ঠিক আছে that notification you have annexed 8th November.
Huh?
8th November.
Yes, sir. Last
8
page
November,
77.
8 November, page 77.
77.
Will Mr. Sanal hand it over?
17 August.
Please.
Malad, kindly consider page number 73 also. 17 August was the first one. 73 onward, Malad, because I placed it, Malad will remember. I placed it that 17 August. First time, Malad, this modified regulation for admission process. Thereafter, others, Malad. So first time on the basis of that, they took admission. 17 August.
কি বলো Referring to the notification of the board dated 8th November 2023, he submits that by dint of such notification, the merit leads of the candidates applied for admission in 2-year DLED course, session 2023, were forwarded through the institution's login for use of the institutes along with necessary guidelines. Therefore, on the date of advertisement for date 2023, the petitioners who claims to be qualified date 2023 were not pursuing DLED course. Thus, they are ineligible to appear, participate in the recruitment process. The 22 এর finding টা ওইখান থেকে নিয়ে নেবে না Mr. Samim, learned advocate appearing for the petitioners, submits that the notification for DLED course has been made on 17th August 2023.
This is a modified regulatory provision. This is not a.
This is for application for admission. Kindly.
First line of the.
For online admission. This is
modified regulatory provision for admission.
This is Malad.
handover
Malad will remember I handed over this.
What did I say, sir?
No, he is submitting lawsuit as the
He
No, no, no.
submits that this is an notification by which applications were invited for
yes.
admission for DLED course,
Yes. 17th August. That's my
which is prior to the date of TET
and not
submission.
and not only that, my date is that on the TET online application last date, there was pursuing. That was my submission. On the last date of online application ended in the year 2023, on that date there was pursuing. That was my submission.
What was the last date?
Uh,
8th October.
No, according, it was extended. Remember, I give a notification and the time to time, first time that was 4/10/2023. Thereafter, it was extended. The board can apprise that last date.
In the notification.
My submission is that, my principally on the last date, they were the pursuing candidate as per the
Just you
criteria.
find out from his brief which is
My
the
lord,
last date.
from which I handed over, my lord. That is, my lord, because the soft copy was filed. The last occasion was 4/10/2023. That was the first time. Oh, sorry. That was, my lord, will remember I handed over that.
They have mentioned that that was extended up to.
They mentioned that is mentioned up to 8.
It says 4th, but they say that it
That
is
is
8th October.
8
So you
October.
say that within this period you have.
Yes. On the last date of online application date, we was pursuing candidate. That was the principle. Last date of online application, we were the pursuing candidate.
2023.
Last date কবে ছিল?
And the last date, as per the said notification in 4th October 2023,
and
within such period, the petitioners took admission to the respective institutes for pursuing their DLED course. Therefore, it cannot be said that the petitioners on the date of advertisement of TET 2023 on 13 September 2023 were not the pursuing candidates. Last date we বললো 4th October. No, how come then on 4th October, if it is prior to that, then on 13th September, how could you be pursuing candidate? Even if I accept your contention that
But
prior to 4th of
17th
October,
no, my contention is that, my lord, in pursuance of, remember 17th August 2023, as per that notification, we took admission in the college.
Okay.
So that was my submission. But that's why, my lord, I referred first 17th August 2023.
2023, they
My lord,
took
kindly,
admission.
because that is not, my lord, kindly here, my lord, kindly see.
I've understood.
Sorry, my lord, pardon me.
By dint of notification dated 17th August 2023,
That might not
issued
the
by
same.
the board for admission to DLED course,
Yes.
the petitioners have taken admission
Yes.
accordingly.
Page number 73 is different, but I handed over this notification.
Prior to.
But kindly see this one. I handed over, remember, I handed over this one. This is separate. A separate notification I handed over last day. When I submit, my lord, a single. Kindly see the heading. The heading is different. Page number 73 is heading, and the heading which I handed over, my lord, that is two different heading. The notification for admission in the DLA 2023-2025 batch. Yes. এই দুটো আলাদা,
এটা রেগুলেশন
admission.
Petition order
Well, the hard copy is because when I handed over hard copy,
Page 73.
Regulation.
কি বললাম? Dated 17th August 2023, issued by the
and pardon me, my lord.
board.
Another
By
thing,
the board.
my lord, the TET certificate, the TET online application extended up to 8. because
It is admitted position.
Yes, yes, my lord. And board says so on that day, my lord, because as that was I handed over, my lord.
Notification for online admission in DLED course was invited by the board. Therefore, issued by the board was made for online admission to 2-year DLED course regular for the session 2023-2025 in the institutes recognized by NCT and affiliated to West Bengal Board of Primary Education. Pursuant thereto, the petitioners have taken admission. Thus, the petitioners cannot be said to be not pursuing candidates on the date of advertisement of date 2023 on 13 September 2023. এটা না ওই 2022 এর যে ক্যান্ডিডেটসরা আছে we also indicate that until and unless the petitioners are allowed to submit their application in respect of the recruitment process, the stage would never arise regarding scrutiny and verification of their certificates. Thus, the petitioners in the writ petitions have made an innocuous prayer for allowing them to participate in the selection process and also for publication of the results. We stop here, no? Come back of recess. Recess board. Continue. After the recess, I
Yes,
come back. এটা দিয়ে দিন ওরা এটা আগে দিয়ে দাও
এটা প্রিন্ট আউট নিয়ে yes, yes, এটা প্রিন্ট আউট আনো না। After recess, my lord, I give the printout of extension of that date online application date, my lord. In printout date. Date 2020 notification reopening.
चलिए Submission হয়ে গেছে না? চলে আসছে 2022 সেম, ঠিক আছে, ওটা থেকে নেবেন 22। তো ওখানে একটা অ্যাড করুন, ইট হ্যাজ বিন strenuously argued on behalf of the petitioner by Mr. Tamim that the validity of the date is for life. Such argument is not acceptable for the reason of the judgment passed in Devesham Supra. এটা 22 হয়ে গেল। Now 2023. Admittedly, the petitioners appeared in date 2023 as pursuing candidates. Some of the petitioners, some of the petitioners. On hearing the learned advocate for the respective parties, it is to be examined as to whether the petitioners were pursuing their DLED course on the date of advertisement of date 2023 on 13 September 2023 or not. Guidelines of NCTE. Guidelines of NCTE. Pursuing candidate, that guideline. The guidelines of NCTE.
Application, application. It's 39.
The guidelines of NCTE
48.
provides as hereunder. Five 48 এর 5টা কোড করবেন, ঠিক আছে? The guidelines for conducting teachers eligibility test within bracket TET of the NCTE in clause 5 provides as hereunder. In the decision of the Honorable Supreme Court in which is that judgment? The pursuing candidate who has been admitted is a pursuing candidate under 5(2). আচ্ছা, এটা আমার ওই জাজমেন্ট একটা দিয়েছিলাম মিস্টার অনিন্দ্য লাহিড়ির একটা ম্যাটারে, ওখানে রিভ করেছে ওটা, হ্যাঁ, অনিন্দ্য লাহিড়ি।
Clarification.
ওঙ্কার, হ্যাঁ ওঙ্কার, ওঙ্কার কারেক্ট।
Special date here side.
হ্যাঁ হ্যাঁ, ওঙ্কার, ওঙ্কার নাথ সিং, হ্যাঁ, yes, yes, that is required. That paragraph I want to quote.
Osman is already quoted in the
Earlier
special date matter.
ওটাতে আছে।
It's a mark copy.
2021.
Omkar Singh and others versus State of Uttar Pradesh, reported in 2021, volume 14 SCC, 486.
Paragraph 11 lordship has quoted in DLA judgment.
হ্যাঁ
Lordship has passed.
এইটা নেবে তো 11 থেকে টেটের এটাও দেওয়া আছে প্যারা 11 থেকে এই অর্ডারটা আর এই ওমকার সিং এর এটা বলা আছে সেটাও করে দেবো ঠিক আছে from the guidelines as well as the aforesaid proposition of Honorable Supreme Court, it manifests that a person pursuing any of the approved teachers education courses is made eligible to appear for TET examination. The petitioners, you can take this back. Thank you. The petitioners contends that, আচ্ছা ঠিক আছে লিখে নিন ওটা লিখে The petitioners contend that soon after the notification issued for admission to DLED course on 17th August 2023, they have taken admission. And on the date of advertisement on 13th September 2023, they were pursuing. As per the notification dated,
extended time.
আরেকটা যে দিল এক্ষুনি বিসিএস এর আগে একটা জিনিস দিলেন এটা কোথায় রাখলেন 17th অগস্ট এটা এক্ষুনি দিল দেখুন 17th অগস্ট হ্যাঁ ঠিক আছে বেশ, ঠিক আছে কি বললাম as per the notification dated 17th August 2025 আর নাম্বারটা নিয়ে নিন 177/WBBPE/DLED/2023 dated 17th August 2023 for online admission in 2-year DLED course regular for the session 23-25. The WBBPE is to prepare and approve the merit lists digitally and forward them to the dedicated login of the institute on and from 11 September 2023 to 16 September 2023 for admission. it is relevant to note that VDA notification number 292/WBBPE/DLED/33 capital A -08/2023 dated 18th November 2023, it was notified by the board that the merit lists of the candidates applied for admission in 2-year DLED course session 2025 are being forwarded through the institute login for use of the institutes along with necessary guidelines. It has further been notified that all the heads of the DLA institutes are instructed to take appropriate measures for admissions of the candidates in the session 2023-2025 in strict maintenance of the enclosed guidelines. Therefore, the admission to the 2-year DLED course would have taken place on a date after 8 November 2023. And not on a prior date, as has been pressed into service on behalf of the petitioners. The advertisement for conducting TATE 2023 was published on 13th September 20. You have annexed that CAN application that
Only last line.
13th September 2023 1945/WBBPE/2023. As per the said notification, the candidates who will acquire minimum eligibility criteria beyond the date of publication of this notification will not be entertained for applying in TATE 2023. This has nothing to do with the pursuing candidates. Then how it will improve the case of the respondents?
After 13 September 2023, on the 8th November 2023, merit is published.
That is proof.
আচ্ছা দাও
Proof merit list published.
ওটাকে আন্ডারলাইন করে দিন, ওটা রাখবো না, ওটা আন্ডারলাইন করুন। কি বলছিলাম যেন? Who were pursuing DLED course, who were pursuing DLED course on the date of advertisement, that is 13 September 2023, was eligible to appear in TATE 2023. The chronology of the dates enumerated above shows that the petitioners who appeared in TATE 2023 were found to be not pursuing such course on the date of advertisement. Such being the position, the TATE qualification of 2023 as of the petitioners cannot be considered to be eligible to take part in the ongoing recruitment process. 2014. With regard to the TATE 2014 candidates, the validity of such certificates have been issued to TATE 14. The validity of the certificates have not been challenged, save and except that they have appeared in TATE 2014 as untrained candidates. It is a fact that the petitioners who have qualified TATE 14 has taken admission to DLED course as per requirement of the NCTE. Next. The publication of the DLED results is awaited. The grievance of the petitioners is that for non-publication of the results, they are unable to take part in the process. It is to be seen whether there is any delay or laches on the part of the board in non-publication of the results. From the record itself, it appears that the courses of 2023 and 2025 admission to the courses have commenced only after 8 November 2023. Stop. It is informed by the learned senior advocate for the board that the final examination of DLED course has been conducted on 15th November 2025. Therefore, this court finds that there is no such laches on the part of the board in publication of the results. Be that as it may, the board is directed to publish the results within a reasonable period of time. As per the notification, the qualification as required is that the candidate ought to have passed the DLED training course along with TATE on the date of advertisement 6/2 ওখানে আলোচনা করা আছে ঠিক আছে as the petitioners none of the petitioners have passed DLED course on the date of publication of the hence on such score as well the petitioners are ineligible to appear in the ongoing recruitment process. With the aforesaid observation, the writ petition stands dismissed. এটা ওনাকে রিটার্ন করে দিন মিস বিশ্বাস টেক ইউর ব্রিফ ব্যাক আচ্ছা ওই যেটা সাপ্লিমেন্টারি লিস্টে যেটা বলছিল ওটা একটু বোর্ডকে বলো তো চেক করতে supplementary listed. You have checked with the board regarding that other two matters?
Lordship, I have given the number.
He says in the morning, Mr. Shamim as well as he submitted.
I have an instruction that board has not yet received the copy as on now. না আজকেই গেছে কিন্তু board এখন অবধি রিসিভ করেনি. So without they receive the copy, how can I get the instruction?
No. If she says that the updation of the date of birth has not been made, for which she cannot.
My lord, what happened, my lord?
This is
The
a
petitioner
factual
got-
aspect, Lordship. There is every possibility. If there is a situation, Lordship can allow them, and we have to obey the order. So, Lordship, unless the board receive the copy and cross verify the same and give me the instruction, because I had a talk at 2 p.m. They have not received till now.
When did you send it?
My lord, after filing, my lord, on Friday.
Friday.
Friday, my lord, today
I
itself
sent
I
it by
served
hand.
another copy. and-
That would have been better, but I think they have posted it. Suppose they have sent. So I have received the copy. They have given me one copy. I will send it to them. Lordship, kindly take it up day after tomorrow. I will take the instruction. If they are entitled, Lordship will.
But what I was up to, that 9th is the last date. If there is a updation in the records in the course of the day, then within this day they could have participated in the recruitment. If the date of birth is the only question, because he has said that there is an order of the division bench to update the date of birth and all, that has not been made.
Division, single bench.
Single coordinate bench.
Coordinate bench.
But because all in pursuance of coordinate bench order, they already issued the death certificate. It shows only invalid because they're not updated.
On the urgent mentioning, supplementary list is written in. On urgent mentioning by the learned advocate for the petitioner, the matter has been listed in the supplementary list. Upon inquiry from the learned advocate for the West Bengal Board of Primary Education, it is informed that the copy of the writ petition has not been received by the board as yet. However, he seeks accommodation to take instructions, appropriate instructions in the matter. শুধু এতে হয়ে যাবে নাকি টপে ফ্রাইডেতে রেখে দেবো? But you have got the track consignment report which has been sent showing something.
দে ওটা দে না, ট্র্যাক ওইটা দে। এফিডেভিট অফ সার্ভিসটা দে। আরে ভাই, অরুণ আর ফাইলটা তো তোর হাতে ছিল।
Okay, we fix it on day after tomorrow. In the meantime, you find out whether service has been effected. And you also take instruction if it is stuck on the point which she has submitted in the morning, then by updation and by a corrigendum, their application may be accepted by the board.
Because
I have received, Lordship, I will communicate with them.
yes, because I'm just showing with my line friend. It is showing in this manner.
Okay.
In this manner, it is shows that invalid. Roll number is invalid because they not updated it. The TET certificate, they issued the TET certificate in pursuance of the coordinate bench order, but they not updated it in their website. That's why most probably it is.
Day after tomorrow, এটাকে আলাদা করে heading করে list করুন।
certificate. DH category.
একটা Thursday তে রাখুন, দুটো তো short matter। হ্যাঁ, 2 PM এ রেখে দিন। On Thursday 2 PM. On Thursday 2 PM.
ডেট করে এলো।
চল, thank you.
এটা আমার।
I'm extremely grateful, my lord, for your patience.
Thank you.
দাদা তুমি 18তে যাও, সব পেটি করেছে।
Item number 576.
I am for the petitioner. Yesterday, I mentioned the matter before your lordships that my lord on similar
For the board, Lordship.
on similar footing, your lordship was pleased to give direction in Akash Mondal matter. The D8 special education candidate are permitted to take part in the TET. Kindly come to page 20. Page 20 of the writ petition, where my lord, I attach the admit card of the petitioner showing that they are the student of D8 special education.
Page 20.
20 to 32. Kindly see the course name. Third column, course name.
Special education.
DS special education. And they are from National Board of Examination in Rehabilitation.
Yes, sir.
The names I have not cross verified.
For a day lordship, asking for a similar order, there is no urgency to accommodate for a day because I have to cross check the candidate. Nothing more on the.
Okay. It will be there tomorrow there. If they are similarly circumstanced, then they should be allowed to.
Yes. I need to just
Tomorrow.
cross verify the
Then tomorrow.
tomorrow.
এটাকে tomorrow তে না miscellaneous heading এ রেখে দিন. How many matters are there? One. Tomorrow.
But tomorrow, as to be mentioned.
Not to be mentioned under miscellaneous heading. At 2 p.m. I will take it up.
Yes.
Hmm?
Yes. Absolutely.
Will I record an order or you'll get a this learned advocate for the West Bengal Board of Primary Education? Learned advocate for the petitioner submits that the petitioners are similarly circumstanced as of the petitioners in the earlier writ petition being WPA number 27540 of 2025, Akash Mondal and others versus State of West Bengal and others. As they are also pursuing DL, which is the course
D8 special education.
D8 special education
Special. From RCI institution.
from RCI approved institutes.
Yes. Affiliated.
Learned advocate, Mr. So-and-so, paraphrase. Learned advocate for the, he seeks for similar orders. Learned advocate, Mr. So-and-so, learned advocate for the board, West Bengal Board of Primary Education, seeks accommodation to take appropriate instruction. List this matter tomorrow, that is 10th, under the heading miscellaneous at 2 p.m.
Grateful.
সাড়ে তিনটে আছে না ওটা সাড়ে তিনটে tomorrow 2 p.m.
Yes. Grateful.
I am the petitioner. Interest on gratuity and area growth. Widow is the petitioner lordship, died in harvest.
Affidavit of service filed on behalf of the petition is taken on record. Taken on record. Who is for the state?
Lordship.
Oh, Mr. Sanal, since you have come, they have mentioned one matter wherein they say that due to updation of the date of birth, the application is not received. So I have asked him, Mr. Chaudhary, to take instruction from the board. He says that copy has not been received. So day after tomorrow, I have fixed it, get the instruction and inform the court so that we can dispose of the writ petition accordingly.
2 p.m.
2 p.m.
One second, my lord. We are thankful to your lordship for patience hearing, nothing else.
I am also thankful to you. Okay, thank you. Affidavit of service filed on behalf of the petition is taken on record. Who is yours for the state? The petitioner, you appear? You will appear in this case? The petitioner,
Husband of the
sir, wait. The petitioner seeks for interest on delayed payment of gratuity and arrear family pension as per pension payment order dated 21st June 2021. from the date of effect of ROPA 2019 till the date of actual payment. The petitioner contains that the husband of the petitioner was appointed as assistant teacher in of 41, Mewakhana Primary School, Post Kantanagar, District Murshidabad. The husband of the petitioner died in harness on 22nd December 2018. The petitioner duly filled up the pension booklet and submitted the same before the appropriate authority. The pension payment order was issued ওরা pension payment order issued টা কেটে দিন তো। The gratuity amount and the arrear family pension as per the pension payment order was disbursed to the petitioner on 4th September 2019. Fourth September. Where is the date? Where is the date that it is given from 4th September? Fourth September.
Minor page 3, para 5.
No. Where is the document that it has been disbursed on 4th September 2019?
Minor. No, no date of death. PP was issued. Minor PP was issued 30th August 2019.
So where do you get this date that it was disbursed on 4th September 2019? The petitioner seeks interest on gratuity and arrear pension from which date? From
14th day of February 2020 as per revised PP.
14th February.
14th February. It is mentioned in the revised PPL also.
From 14th February 2020, from which date the revised pension payment order has been given effect to till the date of
14th day of February
from that day to which date? Actual payment?
till the date of actual payment.
Till the date of actual payment.
As per revised people.
Hence this writ petition. Mr. So and so, learned advocate appearing for the petitioner, submits that the authority concerned ought to have granted interest on the delayed payment of gratuity and arrear of family pension.
My lord, revised gratuity and revised
Revised
gratuity.
on
Entire
revised gratuity and revised arrear of pension, family pension. None appears on behalf, he seeks for appropriate direction. None appears on behalf of the state. Ms. So and so, learned advocate, who usually appears on behalf of the state, is requested to appear in this matter. তারপরে যা থাকে regularization and service copies. Learned advocate for the state leaves the matter to the discretion of the court. In view of the contention made in the writ petition and from the documents, it is found that the interest has not been paid on the revised gratuity and revised arrear of family pension. In view of the above, respondent number, which respondent? Director of pension.
Two, treasury.
Respondent number 2, director of pension and treasury officer. Respondent number
3.
দেখে নেবেন এটা। Treasury officer Lalbagh, director of pension 2 হলো are directed to disburse interest on the revised gratuity and revised arrear family pension at the rate of 8% per annum from the date of the notification of the government order dated 14th February 2020. আচ্ছা বলুন না ওই কন্টেনশনের জায়গায় একটা জায়গায় পিটিশনের কন্টেনশনের জায়গায় একটা জিনিস অ্যাড করুন তো the revision of pension and gratuity under ROPA Rules 2019 has been made in terms of memorandum of the Government of West Bengal bearing number 53/ES/P/P and B/10 capital M -99/2019 dated 14th February 2020. এটা ওখানে দিয়ে দেবেন হ্যাঁ till the date of actual payment of revised gratuity and arrear of family pension in terms of the revised pension payment order. The payment as aforesaid had been made within a period of 12 weeks from date of communication of this order. Stop. Learned advocate for the petition is that you can communicate this order to respond number 2 and 3 for necessary compliance with the aforesaid direction. The writ petition is disposed of.
I am for the petitioner lordship. Interest on gratuity and arrear pension, RUPA 2019.
Same.
Petitioner is the teacher. Petitioner was the teacher. Petitioner himself teacher.
Okay, so the change is petitioner himself is the teacher.
Himself was teacher.
বলে দিই affidavit of service filed on behalf of the petitioner is taken on record. Fix for interest on revised gratuity Uh, The petitioner contains that he was appointed as assistant teacher of which school?
My lord. Brahmanigram JB School. 8 Brahmanigram JB School.
বলে দিন ল্যাঙ্গুয়েজটা বলে দিন Petitioner was appointed as assistant teacher of 8 Brahmanigram GB school JB school post Tagordigi district Murshidabad. Stop. The petitioner retired as a head teacher. Retired from service as head teacher on superannuation on 30th June 2019. The petitioner duly filled up his pension booklet and submitted before the appropriate authority. After a lapse of long time, the revised pension payment order as per ROPA 2019 was issued on 3rd November 2021 and the revised gratuity and revised arrear pension amount was paid to the petitioner on 8th November 2021. However, no interest on delayed payment has been made. Hence this writ petition. Mr. So-and-so learned advocate appearing for the petitioner submits that the petitioner is entitled to interest on the delayed payment of revised gratuity and revised arrear pension. The ROPA has been ওখানে না ওইটা add করে দেবেন the revision of has been made in accordance with ওই government order number such and such যেটা ওখানে ছিল তিনটে লাইন ওখানে কন্টেনশনে ঢুকবে কন্টেনশন হ্যাঁ ওটা কন্টেনশন অফ দি পিটিশনের ওই প্যারাগ্রাফটা ঢুকবে হ্যাঁ আগেরটাতে হুম You are for the state? No. You are for the state? Okay. State of contents matters leaves the matter to the discretion of the court. তারপর same. Allowed.
I am for the petition.
ওটা আগে করবেন দুদিন পরে এটা হলে কিছু সাজিয়ে করবেন এটা
I am for the petitioner lordship. Died in harness. Widow and sons are the petitioners.
What is the prayer?
Petitioner, husband of the petitioner was an clerk,
Yes.
clerk international gratuity.
So the wife is getting pension.
Yes.
Who is the nominee?
In the PPO, my lord. It is mentioned in the PPO. Tika Hazara Mondal, wife and 2 sons.
But this will go 1/3. All the 2 sons are petitioners. All the 2 sons have been arrayed as a party.
Yes, yes.
Affidavit of service filed on behalf of the petitioner is taken on record. This is also ROPA 2019.
Single PPO, lordship.
Huh?
Single PPO.
The arrear of gratuity and arrear family pension. It will be from then which date?
And it was issued on 19 January 2023.
19 January retired from? Died in harness
Died in
on?
Haryana on 22nd February 2021.
So interest will be following the date of such death.
Of death.
Following the date of death.
Following date of death.
Till
Date of actual payment.
Till the date of actual payment. Of the gratuity and arrear of family pension. That means March 13, 2023.
13 March. Mine.
Yeah. Seeks for interest on delayed payment of gratuity amount and arrear pension amount from the date following the date of death of the husband of the deceased employee till the date of actual payment of the gratuity and arrear family pension together with interest. Together with interest is together. The petitioners contained contained that the deceased employee, being the husband of petitioner number 1 and father of petitioner number 2 and 3, was appointed as a primary school
Lower Division Clerk, LDC.
Appointed as lower division clerk
Murshidabad District
in-
Primary School Council.
in Murshidabad District Primary School Council, Post Panchanontala District, Murshidabad. What is his name?
No, madam. He was the lower division clerk of District Primary School Council, Murshidabad.
আগে কোন মুর্শিদাবাদ তো কথাটা পরে দিয়ে দিন। What was his name? What is his name?
Tufen Hajra.
ওটা বলো। এখানে বললাম কি প্রথম বলুন। হুম হুম না না ফিস ভিতরে কন্টেন্ট স্যার বলো বলো পড়ো। That a deceased employee, namely late Tukhen Hajra, being the father and the husband and father, was a lower division clerk in District Primary School Council, Murshidabad. Said Sukhen Hajra died in harness on 22nd February 2021. The pension payment order was issued on 19 January 2023. After much persuasion, the gratuity and arrear pension amount was disbursed in favor of the petitioners in one-third share.
One-third, sir. One-third, one-third, one-third.
One-third share to the extent of one-third share each. However, no interest on delayed payment of gratuity and arrear of family pension was granted to the petitioners. Hence this writ petition. Mr. So and so, learned advocate for the petitioners, submit for specific direction upon respondent number 2, Director of Pension Provident Fund যেটা আছে দেখুন, and 3, Treasury Officer লালবাগ না কান্দি, লালবাগ না কান্দি, top. Learned advocate, Mr. So and so, learned advocate appearing for the state, leaves the matter to the discretion of the court. Yes, sir. Leaves the matter to the discretion of the court. Upon going to the, sorry, look at it. The petitioners have contended that petition continue it is found from the records within bracket annexure P2 that the gratuity and arrear pension has been January 19 it was. What is the date? On which date you received that? 13th March 2023. It is contended It is contended that the petitioners received the arrear of pension and gratuity amount on 13th March 2023. In view of the above, respondents numbers 2 and 3 directly with delayed payment gratuity. Baki the same. Disposed of.
I am for the petition. I am for the petitioner, Lord. One of the petitioner was an assistant teacher. Mother has come, Lords.
It is same. It is ROPA 19. This is ROPA 19.
ROPA 19. Revised gratuity and revised area. Interest to revised gratuity and revised area.
So 14th February 2020.
Yeah.
Same order. Just 14th February. Till the date of actual payment of. So they're going to fact check to Niani. The petitioner contains that her son was assistant teacher of Asolpur Primary School, post Sahiserpur, district Murshidabad. The son of the petitioner died in harness on 19th December 2016. Mehboob Rabbi. He was unmarried. He was married or unmarried?
Unmarried.
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 Where have you stated?
It is mentioned in the TPO, Lordship. First TPO. Case 40.
Which place?
Page 14. I think.
14, which column?
Last portion of the PPT. Name Mina Begum, share 100%, relation mother.
কি বললাম? Garo. The revised pension order the pension payment order was issued in favor of the petitioner. It contention বলছি না? The gratuity amount and arrear family pension amount was disbursed to the petitioner on 17th September 2018.
My lord, as per first detail.
As per the this will be ROPA, which ROPA?
ROPA 2019 lordship.
But 19 comes afterwards, no? (2018) ROPA 2009.
First people, my lord, ROPA 2009.
9 under ROPA 2009. Thereafter, revised PPO was issued under ROPA 2019, and revised PPO has been issued.
Yes. 19th April 2022.
19th April 2022.
Page 15.
19th April 2022. And the amount has been disbursed.
Yes.
The
21st April 2022.
date, the gratuity and the
Revised gratuity.
revised gratuity and revised family pension has already been disbursed to the petitioner. However, no interest on delayed payment has been made. Hence, this writ petition. The same. It will be from which date?
14th day of February.
তাহলে ওই 14th February যে নোটিফিকেশনটা ওটা এ করে দেবে। এটাতে 2019 এ যেটা অর্ডারটা হয়েছে সেভাবে হবে, ঠিক আছে? ডিসপোজড অফ।
Madam, the died in harness case, madam. The wife of the petitioner was an assistant teacher, madam. The husband is before your lordship.
Asking for?
Madam, revised gratuity and arrear pension. Interest on revised gratuity and arrear pension.
Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner contains that she is the wife of the that her husband এখানে husband আছে না? Petitioner contains that his wife was an assistant teacher of 31 Tiktiki Pada Primary School. Stop. The wife of the petitioner died in harness on 5th June 2018. The gratuity amount and arrear family pension was disbursed to the petitioner on 1st February 2019 as per RUPA 2019. However, the interest on delayed payment of gratuity and arrear family pension has not been paid.
But that is the second PPO, my lord. I'm asking for second PPO, my lord. That my lord is saying the first one. First PPO is on 6th of December 2018. I'm asking for my lord 31st of August 2022. That is revised.
কি বললাম না ধরো gratuity amount and arrear family pension was disbursed to the petitioner on 1st February 2019. The revised gratuity and arrear pension was disbursed in terms of revised pension payment order dated 31st August 2022. This was paid on which date?
On 1st of September 2022.
First, and the arrear amount has been paid on 1st of September 2022. However, no interest on the delayed payment has been made. This will be from which date?
From 14th of February 2020.
তাহলে সেম হয়ে গেল 14 February 2020
14th February 2020.
হ্যাঁ ওটার মতোই হবে till the date of payment of revised gratuity and arrear family pension in terms of the said revised pension payment order. Same. Disposed of. State leaves the matter to the discretion of the court. Give your name.
Yeah. For the PPO.
I think the state matter date by Mr. Mansu Ghosh.
I'm paying for interest on gratuity and arrear pension, single PPO, my lord.
This will be from which date?
So far 2019. Husband is the petitioner, mother. Husband, the wife of the petitioner was a mother teacher.
Wife of the petitioner was mother teacher. That is the rank.
That is right.
The wife affidavit of service filed on behalf of the petitioner is taken on record.
Written in my lord, page, paragraph 2 I have written, my lord.
The wife of the petitioner was appointed as a mother teacher in 40 Rameshwarpur Purbopada Junior Basic School, post Rameshwarpur district, Murshidabad. Stop. The petitioner's wife died in harness on 29th October 2021. When was the amount paid?
9th of January 2024. 9th January.
The pension payment order was issued on 18th December 2023 and the gratuity and arrear pension amount was disbursed to the petitioner on 9 January 2024. The petitioner seeks for interest on delayed payment of gratuity and arrear pension amount. Hence this writ petition. Ms. Devjani Sahu, learned advocate for the petitioner, seeks for necessary direction upon respond numbers 2 and 3 for disbursement of interest on the delayed payment of gratuity and arrear pension amount.
From the date of death of the people.
From the date following the date of death of the deceased employee till the payment of actual payment of the gratuity and arrear pension. Learned advocate for the state. Where is he? Do you have anything, you oppose this application or leaves the matter to the discretion of the court? After similar. হুম হুম এটা 8 weeks কখনো করছে 8 weeks করে দেবেন সবগুলো হ্যাঁ কারণ আছে 12 weeks করেছিল একটা 12 weeks করেছিল ওটা 8 weeks করে দেবেন এটা হবে respond number 2 and 3 are directed to pay interest at the rate of 8% per annum on the gratuity and arrear. This will be family pension or pension? Pension amount from the date
Pension, my lord.
arrear family pension from the date following the date of death of the employee concerned till the date of payment of
50% and
the gratuity and arrear family pension. The payment shall be made within a period of 8 weeks from date of communication of this order. ওটা ক্ষেত্রে যে 12 করেছে ওটা 8 weeks করে দেবেন একটা 12 করেছে না সবগুলোতেই 8 weeks করে দেবেন disposed of.
Right. But similar prayer, my lord. Well, here the wife and the daughter of the assistant teacher had come up before your lord. The if family pension issued, my lord.
And this ROPA 2019,
My lord, 29.
it is single booklet or
My lord, revised PQ, my lord.
revised.
Revised. Paying for revised.
Affidavit of service filed on behalf of the petitioner is taken on record. State.
I'm the state panel.
You are in state panel. The petitioner contains that the deceased employee being the husband of petition number 1 and father of petition number 2 was a assistant teacher in 5 Panchagram High Primary School, post Panchagram district, Murshidabad. The deceased employee died in harness on 22nd July 2017. The petitioners duly filled up the pension booklet and submitted before the appropriate authority. The pension payment order was issued on
The first pension payment order was issued on 25th September 2008.
25th September 2018. The revised pension payment order was issued on 27th July 2021. The petitioner, the arrear was on which date this was paid?
On 26th of August 2021.
The arrear of revised
Revised.
gratuity amount and revised arrear. This will be family pension.
My lord.
Family pension amount was disbursed in favor of the petitioners on 26th August 2021. However, no interest on delayed payment of the arrear of revised gratuity amount and revised arrear family pension was paid. Hence, this writ petition. Ms. Devjani Sahu, learned advocate for the petitioners, seeks for specific direction upon respond number 2 and 3 for disbursement of the interest amount. Learned advocate, Mr. None appears on behalf of the state. Mr. So-and-so, learned advocate who usually appears on behalf of the state, is requested to appear in this matter. The same, huh? Learned advocate for the state leaves the matter to the discretion of the court. In view of the above, same order. এটা 14th February. This will be from 14th February.
On 14th February 2022. 2020.
এটা হচ্ছে রোপার 2019 এর। কাজী নেবেন তো? হুম।
Three matters can be taken up.
Within-
Four matters.
Not today. 3:30 I have matters.
Item number 10 वाला डालना
Just wait for some time. See, 3:30 matter is there. See, I will take it up. Don't worry, just wait. I think এটা কি আছে দেখি।
item
আরো যাবে?
My lord, I am for the petition. My lord. Here, my lord, the case is the widow has come before your lordship, my lord. In 1993, the husband of the petitioner, while in service as a primary teacher, got seriously ill. He was bedridden. My lord, thereafter, a committee was formed in 1993, and sub-inspector of school visited the house of the petitioner and, my lord, submitted a report. There, my lord, the sub-inspector of school and the committee opined that the petitioner is cannot work along with this illness, and he is entitled to pension and gratuity, my lord. And thereafter, my lord, immediately thereafter, a few days thereafter, petitioner died. My lord, thereafter, my lord, the wife of the petitioner prayed for family pension. In 2011, in 2010, petitioner received the provident fund, my lord. In 2011, petitioner was asked to submit all her documents relating to pension and gratuity. Petitioner submitted them with proper receipt. My lord, nothing was done.
This was in year 2011.
2011. Nothing was done. In 2024, petitioner moved a writ petition before this honorable court. This honorable court requested the authorities to consider the case. The authorities considered the case and found the petitioner eligible for family pension subject to submission of documents. Petitioner was asked to submit the documents. Petitioner submitted the documents, whatever was available with her at that point of time. Well, now an objection is being raised to give the 1981 challan as to what option petitioner exercised and whether she has her husband has refunded, my lord, that CPF to GPF, my lord, that challan, treasury challan, whether that I have to submit. Because of that, it could not be proceeded. My lord, ultimately, after your lordship's order, my lord, report has been filed wherefrom it is found that the authorities contacted my appointing authority with whom the records should be there. They are saying, my lord, that in this office nothing is available in this office. They have lost the records, my lord. And for that, my lord, I am 89 years presently in ICU, admitted in ICU. My lord, I am
employer's share has been refunded by the husband.
Yes, my lord. That is why, my lord, considering the same, your lordship, kindly come. SI page 37, my lord. Page 37. My lord, kindly come to page 37. This is the report of the committee because the petitioner refunded everything. Petitioner was found eligible for pension and gratuity. My lord, if your lordship kindly read the second paragraph. My lord, may I read with you?
Yes, yes.
My lord, the undersigned opine that Sri Gauranga Roy, my lord, the husband, be allowed pension and gratuity as admissible by the department forthwith. My lord, this is a committee. Considering all this committee found, considering all the papers, I'm eligible. And my lord, kindly see page 60. We received that. Page 60.
So this 37 was submitted before which authority?
My lord, before the DPSC and sub-inspector of schools, I have to supply that because DPSC is my appointing authority. And my lord, page 60, if your lordship kindly comes.
But without that certificate, the giving the pension sanction authority cannot do anything without the document.
How can I? My lord, page 60 kindly come.
Let him complete.
Page 60. Late Gauranga Roy family pension case submitted to DI Paschim DI Krishnagar Nodia dated and the receipt of the SI. So I submitted all the documents including challan and everything. Now
That they have submitted all documents.
No, when did the employee die?
my lord, in 1993.
So during his lifetime, this inquiry report was prepared.
Yes,
And it was held that he was eligible to pension.
yes.
Now
Before
the
that,
widow is before this court seeking for a
family pension
Family
and cash. She has already received my lord provident fund 2010. And my lord, in their report which has been filed, if your lordship kindly see the last page of the report at page 22, the report that they have filed. The department is saying my appointing authority that they do not have any records. And for that, my lord, the petitioner cannot be made to suffer.
Page 60, lordship, in their petition, it is not
Actually, complete.
page 22.
Of their report.
The report has not been filed.
In reference to the captioned subject and your earlier letter, I would like to inform you that the DCRB option as per geo number dated in respect of late Gauranga Roy, it is so and so, is not available in this office. Whatever I may have submitted, my lord, I may have not submitted. What my record should be there. I say I have submitted during my lifetime. That is why the authorities, the committee opined that I am eligible for that. Now, my lord, if the records they have misplaced the records, I cannot be made to suffer. My lord. আরেকটা কথা বলবো ওটা ছাড়াই প্রসিড করো
19
রিপোর্টে
No, at that point of time, was there any option for switching over?
Yes, my lord, in
It was
1980.
there.
Yes, and that is why I switched over to pension scheme.
Okay.
That is why the authority opined, my lord, that he is eligible.
Documents required, the DPS report and the treasury challenge, lordship, in page 19, lordship, in my report.
Yes, yes.
Not all other paper are there. Only these two
Nothing
documents
is
are
required to do with the husband career. The CPF or the
page 19.
treasury challenge.
My lord, if your lordship kindly comes to page 20 of their report. My lord, DCRB is saying in absence of this, you consult with your parent department and proceed for disbursement.
Whatever, then resubmit the case. In case the option is given, is any form, duplicate form is handed over to the party?
No. Man, option is given, my lord. I filled if the option form.
If it is not given, then how come they will produce the option 81?
Yes, my lord. That is the very thing.
This is with them, lordship.
How it will be?
My lord, I have to
Suppose
submit a
officially
treasury
I
to the
give a option under the scheme, DCRB scheme of 81, that I am switching over from CPF to GPF and family pension. Now the entire option and the documents are lying with the department. You do not give any of the receipt to the parties.
Petition.
But that can be, if challan is to be assessed, that can be assessed from the treasury office itself.
Yes.
But option, lordship, DCRB option.
That will be deemed because nobody is going to deposit the treasury challan of the employer's share without opting for.
The department is willing to pay, lordship. That's why department has already sent it to the DPP. But the audit department has returned the case to the
Resolve the issue.
Yes,
She is suffering in ICU, she is admitted, resolve the issue, find out from your office What are the documents necessary?
Your Lordship, may I submit one thing?
Yes.
If your Lordship kindly send the matter to the Education Department, Lordship, they will take that decision, Lordship.
How long?
The department, parent department is the Education Department.
No. You come up with this. You assess from your department. Who is your education department?
Yes, sir.
Then you assess from your department, find out the option has been given or not, find out from their records and give a report to this court whether it is submitted or it is not found, is that does not make her disentitled. Rather, the inquiry report says that her husband is entitled to pension. If he is entitled to pension, then after his demise, the wife will be entitled to pension. That will be the analogy drawn. What remains? Now, if you want to go through that document that is available in the office record itself, find it out.
The record is not with the office, Lordship. The record not in.
How come, madam? Then I have to ask the officer concerned to come to the court and file a report and say that it is not available. It is for the office to keep the record.
It has already been stated, my
Then
lord,
what?
at page 20.
You produce the inquiry report, not the report, but the inquiry, the documents which were produced at the time of holding inquiry, that we produce, upon which it says that the husband of the petitioner is entitled to pension. What are the documents you have produced while holding such inquiry? That will be sufficient. If in the year 1992 the sub-inspector holds an inquiry and says that the husband is entitled to pension, then might have he has gone through all the documents. Those were submitted by her husband. So what were those documents? Produce those documents. Annex those documents with the inquiry report. Come up with those next week. Give a detailed report of this. This has been annexed with the inquiry report.
Yes.
Inquiry.
No, inquiry report I have annexed, they have not, my lord. Page 37, if your lordship kindly read. Sees of my writ petition.
Yes. Mr. Sudipto Dasgupta, learned advocate for the petitioner, submits that the husband of the petitioner was an assistant teacher in Charbir Pada Bancho Ram Primary School, and he has voluntarily retired.
Yes, my lord.
Voluntary.
After my death, my lord, the authorities considered me as died in harness.
Oh, that voluntary retirement was not considered.
It was pending. Before that, I died.
In the year 1991, the husband of the petitioner made a prayer for voluntary retirement before the chairman Nodia District Primary School Council, since he was unable to continue his service due to his illness. Stop. However, pending such prayer, the husband of the petitioner died on
24th of January
1993. Since then, much persuasion has been made by the petitioner before the department concerned for issuance of pension payment order pertaining to family pension. Stop. Though provident fund has been disbursed in favor, provident fund amount has been disbursed in favor of the petitioner, but till date, gratuity has not been paid, no?
Pension and family pension.
Family pension and gratuity has not been disbursed. The department concerned has raised objection as to whether the petitioner's husband has refunded the entire share of the contributory provident fund, employer share, refunded the entire employer share of contributory provident fund and also directed for production of the treasury challan in respect of such refund. He draws the attention of the court to the inquiry report of the sub-inspector of schools at page 37 of the writ petition, wherein it has been held that the husband of the petitioner, late Gaurango Roy, is entitled to pension. Entitled to pension and gratuity. Therefore, the question of further inquiring as to whether the husband of the petitioner opted under the 1981 DCRB scheme for switching over from CPF to GPF and family and pension is uncalled for. State files report. Report কোথায় গেল? Yes. Report filed by the state is taken on record. Learned advocate, Ms. So-and-so, learned advocate for the state submits that the department concerned is willing to disburse the family pension in favor of the petitioner. However, due to want of DCRB documents pertaining to DCRB 81 option and refund treasury challan showing refund of employer's share of CPF, the family pension could not be disbursed to the petitioner. Para. It is found at page 37 of the writ petition that the sub-inspector of schools, Kalyani 2 Circle, has submitted inquiry report with the opinion that pension and gratuity as admissible be allowed in favor of the husband of the petitioners, namely Sri Gaurango Roy. In such backdrop, your respondent number? 7. Respondent number 7 is directed to furnish a detailed report annexing.
PR respondent number 7.
Who has filed this? So Dasgupta, who will file that?
Yes, ma'am. Let me.
No, this inquiry report is made by district sub-inspector of school. So district inspector of
Should be
school.
filed by the district inspector of school.
I have filed the report, Lordship, but detailed report,
Filed respond number 7, district inspector of schools P.E. Nodia is directed to file a further detailed report annexing all the documents that were part of the inquiry report of the sub-inspector of schools dated 6th August 1992. On the returnable date. Next week. আজকে কত মঙ্গলবার নেক্সট মঙ্গল বুধবার দিন দেখো
এই পেজ 37 না বলে দিচ্ছি যে এইটা
নেক্সট উইক ওটা এরকম 3টের সময় দিন না টিউসডে 3 PM
Tuesday 3 PM deeply okay.
Madam, then it will go to January. He is suffering, just expedite this so that we can get the form. Since 2011 it is pending. Who?
Long period, the petitioner, Lordship.
Why would they take steps?
93, the petitioner died, Lordship, thereafter they
It is the bounden duty of the state to provide pension while they will approach, and then the pension will be allowed. If 1 or 2 days, it will not matter, but don't go another week, because that will be the end of this, will fall in the winter vacation. That will come in the month of January then. Let us see what happens in the coming week. You find out from your department. If it is there, then fine.
Yes, sure.
I can get
For the petition.
Here.
The interest on revised gratuity and arrear pension amount. Now, death case manner, similar prayer. Husband of the petitioner was a head clerk, head teacher,
2019.
2019, madam, revised.
Affidavit of service filed on behalf of the petitioner is taken on record. The petition, by the present writ petition, the petitioner seeks for interest on delayed payment of revised gratuity amount and arrear family pension amount as per pension payment order dated 14 September 2021 from the date of effect of ROPA 2019 till the date of actual payment of the arrear amounts. The petitioner contains that her husband was an assistant teacher of 32
Was a head teacher when he died.
32 Bhola Danga Adivasi Primary School, Post Palsanda More, District Murshidabad. Stop. The petitioner's husband died in harness on 26 December 2016 while discharging his functions as a head teacher of the said school. The pension payment order was issued on 29th November 2017 and the revised pension payment order was issued on 14 September 2021. The gratuity amount and arrear family pension was disbursed on 2nd January 2018 and the revised was received on which date?
15 September 2000.
And the revised gratuity and revised arrear of family pension was received on 15th September 2021. However, no interest was paid on the delayed payment. Hence, this writ petition. Ms. Devjani Sahu, learned advocate for the petitioner. আচ্ছা এইটা একটু দিয়ে দেবেন তো এই জায়গাটা ওদের কন্টেনশন এ under ROPA 2019 there was revision of pension gratuity and computation of pension of the pensioners. VDA Memorandum of the Government of West Bengal bearing number 53/ES/P/P and B/10 capital M dash 99/2019 dated 14th February 2020. Ms. Devjani Saul, learned advocate for the petitioner, seeks for specific direction upon respondent numbers 2 and 3 for disbursement of the interest on the arrear of pension, gratuity and arrear of family pension from the date ROPA 2019 was given effect to till the date of actual payment of the arrear amount. Learned advocate for the state leaves the matter. Yes, you have anything to say?
No.
Leaves the matter to the discretion of the court. বাকিটা এটার মধ্যে করে দেন 8 weeks এর মধ্যে ডিসবার্স করে দেন এটা 12 আছে 8 weeks করে দেবেন ঠিক আছে আর ডিরেকশন টু রেসপন্ড নাম্বার 2 and 3 এই নিয়ে গেছে অমিতাভ বাবু নিয়ে গেছে হ্যাঁ ডিসপোজ অফ
With the lordship, may I mention one thing, my lord?
No.
Two matters, my lord.
No mentioning.
Two matters were mentioned before
No
your lordship
mentioning.
in the morning that at 3:30 p.m. these matters will be coming up. I'm appearing for the state.
Where were you?
3:30 p.m. my lord. The time is fixed.
3:30 p.m. it was taken up.
3:30 তে হয়নি এই ম্যাটার হয়নি এটা এর বাইরে ডিলিস্টেড ম্যাটার মানে লিস্টে নেই
Which matter, sir?
এটা হলো তো আমাদের বলবে কেন আমাদের তো বলা উচিত
হ্যাঁ কি হয়েছে
They have given notice that the matter will be heard on 3:30.
Oh, আচ্ছা আচ্ছা
My lord,
you are appearing for which authority?
State of West Bengal. State, my lord.
You are there on 3:30?
Huh?
3:30 you were there?
Yeah.
Oh.
I was not here. Just now I heard when inquiry. He is appearing in one matter, I am appearing in
কি দিয়েছো
1 and 2.
কবে আসছে ওটা এটা কবে গেল ডেটটা কবে হলো give your name give your name for the state কবে আসছে on 11 this will come up on give your name for the state the board has been directed to take a instruction from the authority. The learned advocate has been directed to take a instruction from the authority whether updation with regard to what has been prayed by the petitioner has been made or not. Give your name. Yes. This is
Based on revised gratuity and arrear pension. Revised part record 2019.
ADS.
Dad in harness is wife is
first PPO was issued on which date? Single PPO.
No, revised PPO. 29th of November 2017. First PPO.
And thereafter 6 March.
March 2022.
Same. Ashun. Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for same. আমি জাস্ট এই কন্টেনশন এর স্ট্যাটাসটা বলে দিলে হয়ে যাবে না করে দেবেন সেম তো অর্ডার শুধু 12 উইকের জায়গায় 8 weeks করে দেবেন ডিসপোজড অফ ইউ আর ফর দি স্টেট
Revised PPO, petitioner himself has come. He was the head clerk. It's been revised gratuity and revised area family pension.
So interest.
Item 10 after item 2.
This single PP or
No, revised PPO. Roman 29.
In as one, how much 2? Duto matters.
First PPO 12th August 2016. And the second one revised on 9th December 2022.
Paragraph number 4 and 5. বুঝলেন
না
একটা কি বলে দেবো
has come up.
করে নেবেন স্টেট ডিসপোজড অফ
This is I have served the copy upon the respondent, my lord. It is admitted that my due salary already paid by the DPSC. And my lord, chairman, your lordship, I have annexed the petition, page P45. P45, my lord, where
some writ petitioner moved this application before the Honorable High Court. Huh? Identical point and my lord self-same. Among admitted my lord due salary. Your lordship can see the page 45. Page 45, my lord. 10, serial number 10. Petitioner also self-same, player self-same, my lord, claim. The petitioner shall be paid the salary same 11th February 2014 to 31st August 2014 mandatorily and positively within a period of 1 month from the date of the decision of the court. Now, this is my prayer, my lord. I have already served the copy upon the respondent. Petitioner claim also self-same, my lord. Paragraph 19.
Self-same.
Absolutely. What? My other prayer appear on behalf of the Chairman Council.
DPSC, you are for DPSC?
And my lord, self-same case, my lord, is already my lord.
Released by?
Release the side. সকলেই জানছে
Chairman divisible.
Date of joining lordship kindly A, B, C, D, E, F, C, H. Date of joining lordship. Well, this is not the by the criteria. This is not the case. My claim only to pay the due salary. And my lord, on the basis of the salary. And already paragraph 8 lordship, second period has been paragraph 9 lordship. Kindly look into this. The salaries of the petitioner have not been paid for the period as stated herein below. Page 10, paragraph 9. This is my case.
Check it and file a report. File a report. File a report with regard to the contentions raised in the writ petition as to non-payment of the salary.
Yes.
Your
And my lord, your
by what-
lordship, my lord, till my lord, I was other claimant also filing that your lordship directed to file a report. And the report is with the said chairman, advocate chairman. Yes, it is the due to salaries of the petition.
How many petitioners are there?
Right. Lordship 1, 2, 3, 8. Follow the 8.
Paid
This color kitchen.
Court fees have been paid.
Understand, dear.
Court fees paid.
No, so for one. I'm paying for this, my lord, if it is necessary, my lord.
Petition is directed to deposit ad valorem court fees and file documents showing such payment on the returnable date. DPSC, which place?
District Primary School Council, Purbo.
All the respondents from are
under the same council.
Council District Purbo.
Yes. All the petitioners
Substance are rendering their service
under the same.
DPSC, District Primary School Council,
Purbo.
Purbo.
District Primary School, Purbo Mednipur is directed to file a report on the returnable date. Please, this matter, speaker, please, this matter 1 week after the ensuing winter vacation. 1 week after ensuing winter vacation.
Chapter being
1 week after the vacation. Affidavit of service filed on behalf of the petition is taken on record. 1 week after the winter vacation.
Next matter also self-same matter.
Same order.
Same.
Purbo Mednipur.
And for the state matter.
Same matter.
Affidavit of service filed on behalf of the petition is taken on record by the present item number
14. 16. Sorry.
By the present writ petition, the petitioner seek for disbursement of arrear salaries. Advocate আগে থেকে পিটিশনকে ডিরেকশন দিল অ্যাডভোকেট কোর্ট ফিসে সেম সেম অ্যাডভোকেট কোর্ট আর রিপোর্ট ফাইল করুন ওই লাইনটা ওখানে অ্যাড করে দেবেন তো বাই দ্য প্রেজেন্ট রিপিটেশন সেম ডেটে এসে লাভার ওই করে
আমি কিছু আইটেম 15 জেনারেল নামটা দিলে
The matter relating to CPF to GPF. Here, we seeks to refund the amount. Already decided by your lordship judgment. Will pass.
My lord, praying for passport. Thank you. Thank you. Yes. Thank you very much. My lord, in this matter,
you're filing a report or affidavit in opposition.
I have a report, but going through the entire case, if your lordship takes a look at the case, in fact, I'll take your lordship through the list of dates. The list of dates are very important.
No. If you are intending to file any report or opposition to what has been stated in the writ petition, we can take it up and hear it.
The point is, my lord, the report is
Exceed to what have been paid, then direction will be issued permitting the petitioner to deposit that amount, and accordingly they will calculate the interest and the additional interest.
Absolutely. Kindly allows me for a moment, just 2 minutes. I have a report, but this will not be a conducive one. So there's no point in placing this before your lordship, because it seems that the DIS school doesn't know what he's speaking about. So let me bring it to your notice what is there in the case itself. Thereafter, it's necessary, my lord, we'll put up a proper report. Kindly sees the petitioner's husband joined in the school list of dates, my lord, on the 27th of February 1955. Just the list of dates, my lord. It'll take us to that. Thereafter, if your lordship really comes down 4 columns, 31st of May 1996, petitioner's husband retired from his service. Important. 96, he retires. Then the husband dies on 22nd of April 2017. 2 columns. Nothing made during this period of time. No changes sought for, nothing done. Then the widow comes and makes a representation on the 26th of September 2024. This is not maintainable. We could understand, my lord, if the petitioner's husband during his lifetime had done it, but he died in 2017 and this was made in 2024. Then it will be a posthumous thing. It's not there under any scheme that the posthumous entry by a widow can bring back those past service records, GPF, GPF, all those. You could have made an application while he was alive, died subsequently, the judgment's a square on the face, staring at my face, my lord. But when the application is made after 6 years, 7 years, after the demise of the person, I'm sorry, my lord, it doesn't fit any of the judgments as well as the GOs, whatever is there.
Okay. Yes.
See, case entitlement of the pension decided in the year 2022 by the Honorable Supreme Court.
We have not exercised our earlier procedure. ROPA was exercised.
Yes, sir. Rope exercise, Lordship.
Which inaction?
Indictment of regarding pension law already decided in the year 22 by the Supreme Court. Last, thereafter, Lordship, the Promila Vera judgment and also Muktumani Pal judgment decided. Thereafter, petitioner came to know and file application to consider his case, and as the petitioner case has not been considered, petitioner filed. Relied upon Lordship, the one judgment, single bench judgment, passed by Honorable Justice Radhasekhar Mantha, may submit the judgment, Lordship. Paragraph started from regarding delay. Paragraph 8 to 50.
Can I get a copy of the judgment unreported?
Accepted by the government, Lordship.
Kindly sees in the judgment whether the person has applied or his widow has applied after 7 years. Factually incorrect. Judgment একটা copy না দিলে তো আমি ভাই argue করতে পারবো না। Unreported judgments copy must be given.
Here, husband died in harness in the year 86.
Para 14.
The judgment of the Supreme Court.
Twenty-two. 24.
Accepted this judgment, Lordship.
My lord, I'm going through the first judgment which my learned friend has given. It's a single.
Promila Vera is the answer.
Yes.
Which has been quoted in the said order of Justice Mantha.
Yes.
This was a case where there was a 37 years of delay.
Delay,
Court
but
says that
yes, yes.
it has been stated that this went up to the Supreme Court. Honorable Supreme Court has disposed of this case in the year 2022.
True.
Correct. Now in Promila Behra, the court says that, see, the widow of a deceased employee cannot be blamed for the delay by courts intervening pension and
that's not with
entitlement.
me. Promila Bera কোথায়?
Page number 4.
Page number 4.
Yes. See, the family of the deceased employee was paid gratuity in terms of ROPA 1990. Here, the option of ROPA 1990 has been exercised. So there is no question of giving a fresh option. Is automatically entitled to pension. That means the employee is given an option. He is entitled to pension. Now, the widow cannot be blamed for the delay in the court proceedings, which has been disposed of on 5th January 2022.
That is a different proceeding, where I've given to understand here, reading this, that he was having a disciplinary action against him in all possibility, if I'm not wrong.
Correct.
That delayed his proceeding.
This Pramila Behra,
Yes.
after, going through all the decisions, have lays down and concluded as follows.
Only one thing remains to be.
2022 is the SLP which culminated in all the rights of the
Absolutely. The point is, unless we get the actual factual matrix, that whether this particular person.
Suppose the application, file an affidavit in opposition. File a
I'll do
report
that.
of the detailed report you want to file it.
Whatever, I'll give an affidavit in that case,
Pramila Behra, which has been quoted in this order.
Absolutely.
File a report to that. Only for the sake of opposing, it will not do.
I never do that.
Oh.
Even if it's done, I do not lose anything from my pocket, Malad. How do I stand to lose, Malad? I don't stand to lose. But I must bring the factual context before your Lordship. If it is squarely within the judgment, your Lordship please passes the order.
Widows are entitled as per Pramila Behra in other cases. Why this particular widow will be deprived?
Only one thing I was asking myself, but only one thing I was asking. I'm only asking one question to myself while I was reading this. I was also talking about this to my learned juniors. I told them, supposing a person is entitled to this particular, he is entitled during his lifetime. Absolutely. He doesn't exercise. After 7 years of his demise, that person is no more. The entire thing comes to an end much earlier, maybe 20 years back. Now, after 7 years of his demise, the widow can exercise that option in the name of a dead man. Is it possible to comprehend that that widow can now exercise? Then not only that widow, now the widow's child can also exercise after 15 years. Then his child can ask it after 25 years. There's no end to the entire sequences. If that is the point of law, which we are going to understand now. But that is what I was, it was troubling me. Otherwise, I will not oppose for the heck of opposing.
Then in the last part of it, last part of this order, which he has placed, the
Government can discriminate to the employee, all employees.
the court has also taken into consideration that there were 37 years of delay, so in 1986 and 2022. Considering that, the court says that the said delay cannot stand in the way of permitting the petitioner to exercise option phrase in Avijit by their decision.
Paragraph 15. But it says that the delay is not attributable to the petitioner. Here, the factual matrix really changes, Malad. The delay was due to something else. Here, there was, I think, if I've read properly, Malad, I had to go through a swift glance of the entire thing. It seems like there was a, in this matter, there was a disciplinary proceeding.
Yes.
Yes, Malad, paragraph 10. The court notes that indeed delay and laches often defeats the right to writ of mandamus. It is, however, seen that the subject matter of R case so-and-so was a disciplinary proceeding against an employee. The entertainment of the writ petition notwithstanding delay of 37 years in the instant case has already been discussed at some length in a subsequent and preceding paragraph. Family pension, terminal benefits or claim thereto cannot even otherwise be hit by the principles of delay and laches or even bound by any period of limitation. So this 37 years, which is now been shown out here, is because of this particular cause that there was, my lord, something more to it. There was a disciplinary proceeding. I could very well understand there was a disciplinary proceeding he was fighting. And it took him 37 years to get out of it. Naturally, he'll get the benefit of 37 years and he can make the application then and there. But during his lifetime, he doesn't make it. Everything is gone. He actually expires nearly 7 years back. And actually, he retires in 1996.
In this case, when was the application filed?
Sorry?
When was the application filed? When was the petitioner approached?
2024. And he died on 9th of December, I'm sorry, 31st of May 1996. Petitioner died.
Fact, in this decision of Justice Mantha, that is a fact which has been answered in paragraph 12 of the decision, because that disciplinary proceeding did not take 37 years. The person died in harness in 1986. And then it goes to state that this SLP has culminated in 2022.
Unless we...
Not that 37 years, the disciplinary proceeding was pending. He died in harness in 1986, which goes to show that the disciplinary proceeding
did not
end.
Yes.
Prior to that, he has died.
Yes.
Now, whether the widow can exercise rights, this went up to Supreme Court, and it took 37 years. Now, this has been considered.
It was,
you go through the entire...
It was immediately thereafter that the widow took the entire issue and went to the Supreme Court up to. But
Since
yeah,
2022, this has been disposed of. This has been dealt with in Pramila Behera. If you want to go through that judgment,
I'll come back with those judgments. But my learned friend is relying upon, let her give me those decisions here.
Regarding the law on that,
We are not very we are not very we don't get much option from the state. So we have to take out everything out here ourselves. It's not the entire whatever is given. If I give it to your lordship, this particular note, this will be absolutely irrelevant, my lord. I cannot hand this out. I'll come back and let her give me the decisions that she's relying upon.
Jyoti Basu, senior advocate, appearing for the state, seeks accommodation to file a detailed report. Let such a report be filed on the returnable date. Please, this matter 1 week after the winter vacation.
Your lordship wants a detailed report. The report would be very bad, my lord. Let me give an affidavit in opposition. I don't believe in reports, my lord.
But
and I cannot hand up this. I'm sorry. I was slipping in making my submission. This report, sir. I'll give an opposition.
You have to, base your opposition to the documents of the state.
Exactly. So with those documents not here, I cannot. A short report, short date for that, and then they can give 1 week.
File an affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within 1 week of reopening of the court after winter vacation. A reply thereto, if any, be filed within a week thereafter. Advance copy of the affidavit in opposition may handed over to the learned advocate for the petitioner. Please, this matter 2 weeks after the winter vacation.
Fix the date.
Yes,
after 2 weeks. Pension is Monday, but which is 19th January.
What is it? Malad, I'm not doing it for the sake of opposing, Malad. I want to see, have it seen by lordship what really goes into the entire thing. Sometimes the state doesn't really have the option because they don't get the service of the district inspector of schools, Malad. That's why I'm here. Otherwise, Malad, what? It doesn't cost me anything, Malad, to say yes to it. Grateful, Malad. I'm grateful.
Item 16.
Lordship 16, similar, Lordship. And I will file a short affidavit, Lordship. Similar situation.
Same order.
Grateful, Lordship.
Item 7. And for the petitioner lordship, here is the family pension lordship. Petitioner being the unmarried daughter, paying family pension. Father was the teacher and father died. Thereafter, mother died. That is my available service. Service to
Mother was receiving pension.
yes, Lordship.
Now the petitioner is the unmarried daughter,
Widow daughter.
widow daughter.
Yes.
Who is for the state?
I do. I have served.
You appear. Any representation has been made?
Yes, Lordship. That is Lordship. Page 21.
Who will consider this representation?
DI.
DI. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for grant of family pension. Why 5th August 2021 is the date of the death of mother,
Mother Lordship.
with effect from
August.
the date following the date of death of the mother. That is 5th August 2021. 2021. The petitioner contends that her father, late Vishnu Pado Adgiri, joined as an assistant teacher in Bazda Primary School, Bazda Police Station, the Police Station, Moyna. The petitioner's father retired from service on superannuation on 30th September 1984. Pension payment order was issued in favor of the father of the petitioner in the year 1993.
2003 Lordship.
Huh? Father pension payment order was issued in favor of the father on which day?
Father. In favor of the father.
1993.
Yes. No, Lordship, there is no date, Lordship.
You have stated in para 4 of 1993.
Yes. Para 4 Lordship, but in the PPO there is no date mentioned, Lordship.
The
PPO is Lordship annexed P3 page 16.
P6.
P6 page 16. Kindly mention the file number, Lordship.
What is the file number? 1990.
File number, Lordship.
When was the pension granted in favor of the father?
Father, Lordship. Come to serial, in the PPO, serial number 7, Lordship. First, Lordship, 1st January 88 from.
No.
No. 87.
88.
A.
You have a copy of that father's PPO with you?
Yes, Lordship.
You're carrying?
Yes, PPO, Lordship.
PPO of the father.
Yes, Lordship.
You have not annexed that?
Page 16.
It's 16. Adgiri.
একটু দেখো
Date
এটা।
দেখো।
একটু এটা দেখো।
In 89. ভুল।
ডেটটা এখানে মেনশন।
আসুন 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 ঠিক আছে আসুন কি বললাম 1989. The father of the petitioner died on 11th August 2019. Family pension was granted in favor of mother of the petitioner, namely Aloka Adgiri. The petitioner's mother died on 4th August 2021. The petitioner's husband died on 8th September 2015. Stop. The petitioner is the widowed daughter of the deceased employee. On 20th May 2025, the petitioner made a representation before the District Inspector of Schools, Primary Education, Purbo Medinipur, as well as other authorities for grant of family pension in her favor. However, no steps have been taken, hence this writ petition. Miss So-and-so, learned Mrs. So-and-so, learned advocate appearing for the petitioner, submits that the matter be relegated to the respond number, District Inspector, relegated to respond number 4.
Yes. পূর্ব মেদিনীপুর। ডিআইপি পূর্ব মেদিনীপুর।
Respond number 4 for consideration of the prayer of the petitioner dated 20th May 2025. None appears. You are for the state.
Yes, I am in panel.
None appears on behalf of the state. Miss So-and-so, learned advocate who usually appears on behalf of the state, is requested to appear in this matter. She also submits that the matter be sent to the concerned authority for their consideration. In view of the submissions advanced on behalf of the appearing parties, respondent number 4, District Inspector of Schools, PE Purbo Medinipur, is directed to consider the representation/application of the petitioner dated 20th May 2025. 20th May. For grant of family pension in her favor. And dispose of the same by a reasoned order in accordance with law within a period of 6 weeks from date of communication of this order. With the aforesaid direction, it may dispose.